సార్ కోర్ట్ ఆఫీసా? కోర్ట్ ఆఫీసా?
My lord, I'm the appellant, my lord.
My lord, the memo for posting, your lordship, it was filed on 31/7/2024. The writ petition, there is a direction by the state government to transfer the funds from one district mineral foundation to the another. There is a exorbitant amount being ordered to be transferred, and it will be completely deprived of the funds, your lordship. State government has illegally directed it to be transferred. And central government also has said that there is a purpose for which the funds has to be transferred. Your lordship, that on July, they've already asked me to transfer the huge amount of money. It is PIL, but it's been wrongly classified as GM, your lordship.
My lord, I'm a appellant, my lord. They are trying to disentitle me from my land, my lord.
Not really.
They are trying to disentitle me from the land, my lord. This has never been listed. We have filed in January, my lord. There's an urgency, my lord.
My lord, there is
I
another.
humbly beg, my lord.
My lord, there is another memo, your lordship, where there's another memo, your lordship, of my colleague, where it's a contempt petition, your lordship. The site was allotted to the person, and the single judge had ordered to be the money to be refunded with interest. The officer has returned the money, but not the interest, your lordship. The petition is pending, your lordship, and the person is deprived of his funds for quite a long time. Oblige.
My lord, necessary for appellant, number for posting. My lord, KIDB released the amount to the stranger person. So supposed to be listed on just 12th this month, but so far is not listed. So it is very urgent, madam, my lord. Because of that stranger person, he again is releasing one more property compensation amount. Kindly request on Monday, madam.
Very important.
My lord, matter is urgent.
Education matter, my lord. See, the CET counseling is going on, my lord. I have applied for CET counseling.
My lord.
Tomorrow.
Change of mutation and
My lord, I am running a Jaggery unit. Here. My lord, I am running a Jaggery unit, my lord. My lord, I am running a Jaggery unit. The Karnataka Pollution Control Board have issued me a notice asking me to issue OCEMS, my lord. That costs 60 lakhs. My unit costs only 10 lakhs, my lord. I am running the fire, my lord. It's a green unit. Now, my lord, based on that notice, my lord, now the trade license is to be cancelled and they have issued the final notice to me, my lord. I am challenging that notice itself, my lord. My lord, if they close my Jaggery unit, my lord, so many sugar canes will get spoiled, my lord. Filed it in month of August, my lord.
serial number 7, my lord.
20.
My lord. My lord, I am mentioning a matter. My lord. My lord, I am mentioning a writ petition PIL. It's very urgent because due to the corruption in mismanagement by this Bitcoin and respondents are not have curbed this corruption, loss of public money. So this should be listed. A very serious issue by Bitcoin. After. And one another matter I am mentioning, office objects have been complied with long back, not listed. This writ appeal number 769. So this should be listed very urgent. This stage against me. Give some specific date. Not being long back. It was. The stay is against me. I am the owner of the property. Matter is very urgent, so that's why the stranger person is getting second time also the compensation amount. It came third time also they're going to issue my letter. That's why.
Serial number.
Your Lordship, the petitioner is a stone crusher unit, Your Lordship. The Department of Mines and Geology has issued the notice and the petitioner is now in the apprehension of cancellation of license, Your Lordship. But Your Lordship, the action is taken pursuant to the complaint made by the retired partners, Your Lordship. So on the same issue, we are pursuing a commercial suit, Your Lordship. So Your Lordship, the matter may be heard on Monday, Your Lordship. Your Lordship, it's urgent, Your Lordship. The notice is issued and the petitioner's business is at stake, Your Lordship. Your lordship, it's listed before this honorable court only, your lordship. It's listed before. Your lordship, it's urgent, your lordships, because your lordship, kind attention may be taken, your lordship, because the huge business is at stake, your lordship. The retired partners are unnecessarily trying to disturb the business.
Your lordship, for the complainant in this matter, the settlement has been arrived.
Yeah,
between the
they will
complainant
meet,
and the
we burn
accused
it.
persons. A withdrawal memo has been filed, it may be posted before the vacation unit. Your lordship, we've withdrawn the matter. Yes, your lordship, because settlement has been arrived at.
Serial number 24, my lord, in the first list. It is complied, my lord, it may be dropped. Serial number 24, my lord. (456) of complainant, my lord. Yes, my lord.
Serial number 2
Obliged.
is complied.
Serial number 20 and 34, ma'am. Kindly place for a short accommodation. I am for the petitioner, madam. Serial number 20 and 34, madam.
That's all, my lord.
20 and 34, madam. Serial number. But the senior has been little bit inconvenienced, madam. She is not feeling well.
My lord, serial
Serial
number,
number 30, please, madam.
I saw in the corridor.
my lord, serial number 37.
2 is complied. Serial number 2 is complied. I am appear for complainant. List number 1, serial number 2, my lord, is complained, my lord. Kindly may drop the. Yes, madam. Much.
Serial number 38, my lord, I am for the respondent.
Serial number 17, my lord, for the appellant, 17. Paying for the short accommodation, ma'am. Six, sir.
Please.
My lord,
Respondent, 38. I'm paying for the short accommodation to file the objection. For the main petition and for the IA. No, we have communicated to them.
Amen.
Pallavi. My senior name is meant to Isaac. And for the respondent.
my lord,
After vacation.
my lord,
My lord.
my lord, serial number 37, my lords, appearing for appellants,
But I appear
Seeking-
for respondent in this case.
seeking for a short
There is
accommodation.
urgency in the matter. I
Any-
oppose adjournment.
My
I am
lord,
for the respondent.
it's
I
any
oppose
convenient,
adjournment. I oppose adjournment. No, I am for the respondent, ma'am. I am opposing the adjournment.
my lords, any convenient date next week, my lords, my seniors, there's personal inconvenience for senior today, my lords. My lords,
Hmm.
List number 3, serial number 7, my lord. Furnishing memo for withdrawal, my lord. Serial number 3 in list, serial number 7 in list 3, my lord. List number 3, serial number 7, my lord. 3, yes, my lord. Furnishing, serial number 7, furnishing memo for withdrawal, my lord. Petitioner, my lord.
Yes, my lord, PIL.
With your lordship's kind permission. With your lordship's kind permission. My lord.
My lords, list number 3, serial number 4 and 10, my lords. Senior's mother is hospitalized, is in the ICU. Kindly grant us 1 week. List number 3, my lords. List number 3, serial number 4 and 10. 3, my lords. Yes, my lord. Yes, my lord. Kindly grant us 1 week's time. Serial's mother is hospitalized. Much of it.
Your lordship, this is 21 matter. Since many years I moved the court. The bench is not for me. Even yesterday I also moved. The Gulbarga bench is not sitting. So I pray your honor to have Friday this one. I'm 83 years old not.
My lord, with your lordship's kind permission. Lord, serial number 8.
21 of 21. Ashwatthapa. ಏನು ಸ್ಟೈಲ್ ನಲ್ಲಿ ಕೂತಿದ್ದಾನೆ? ಯಾರು ಅಡ್ವೊಕೇಟ್? List number 3, item number 6, which is party matter, and more adjournment. 6, I call list number 3, item number 6. And seeking 2 more weeks to it for curing the defects.
You want adjournment?
Now I am seeking adjournment 2 weeks.
2 weeks, 6, all right. 2 weeks. 6 weeks is granted for removal of office of this.
My lords,
Lordship's kind permission, my lord.
Yes,
With your lordship's serial number 8. My lord, I need to comply office objections. There are several office objections.
serial number 18, which board?
Please, my lord.
My lord,
Office of
Serial number 8, my lord.
1, serial number 8. Serial number 1, that is. So that is PIL.
Yes, my lord, PAL.
No, let it be called out.
Please, my lord.
Yes, let it be called out, then we'll see whether to grant.
Please, my lord.
Yes.
my lord,
my lords, this is a PIL matter pertaining to the establishment of an independent civil services board. Your lordship was pleased to direct the respondents on the previous occasion to file their reply invariably by 11th, my lords. They have still not filed any
Office
response.
objection ಇದೆಯಾ
Not
ಇಲ್ವಾ
have-
No
ಇದರಲ್ಲಿ?
memo is necessary. Let it.
No, my lords, it's listed on 16th of next month, my lords. It was not called out. Unfortunately, it did not reach the bench on 11th. It's posted on 16th, my lords, but they were asked to reply invariably by 11th.
Will be extended.
Next week, my lords.
Judicially given date by judicial order will not be changed unless you file interim application for preponement.
My lords, it did not reach the bench on the previous
We
occasion.
are saying that if the matter is adjourned by judicial order to a particular date,
Yes,
it will not be preponed unless you file IA showing the urgency. By memo, the
I
judicial
shall-
order can't be changed, that's all.
I shall file the,
My lord, serial number 66, my lord, in the 230 list, today's list 1. My lord, where there was a observation made by the learned single judge, which my lord I had moved for some time, saying that I would like to interact a payment of 14 crores. My lord, could I seek for 10 days time, my lord? There's a
Serial number?
little- 66, my lord, 230, 66.
Other side is no objection.
I have informed them, my lord.
That is that contractual.
Yes, 14 crores. My lord, there's a little difficulty, my lord, trying to resolve the issue, my lord.
Why it was so asked to that you should pay? Some observations of learned.
Yes, my lord, I had, because there was a undertaking,
Agreed before learned.
yes, learned single judge.
At the request of learned additional government advocate, Srimati Nilofar Akbar, and with consent of learned respondent, stand over to. You are there, 21st of October,
My lord,
21st October.
very well, I'm obliged, my lord.
Kindly, third list, serial 24, my lord.
Third,
Objections are to file a typed copy. Petition's typed copy, I have filed it.
third list,
Yes,
third list,
the third list, serial
Serial
24.
24,
Disconnected. Yes,
24.
24.
So
14 flats, electricity disconnected. I had an interim order before the learner single judge, my lord. The respondent has produced certain documents which I am unable to get it original, my lord, to get it typed.
we grant 3 weeks time to remove the office.
Petitioners documents I have filed it. Respondent documents may taken. At the time being, let it be dismissed, my lord. Urgency is electricity disconnected.
No, will not.
That's.
Will not
My copies are filed, my lord, type copy. The respondent has produced certain documents which is not legible. I have to get it from the office and get it typed in. 1 week for that one, my lord. For the time being, it may be dispensed this and I have to get from the respondent. My copies are filed.
It is your business, not our
The
business.
respondent, they are not very good copies, my lord, before the learner single judge, my lord.
3 weeks time is granted to remove the office of justice, whereafter the appeal may be posted for admission. At last, yes.
Seal number 1, Abhishek Mali Patil.
Malods, I appear, Malods. Regarding Malods UG medical counseling, student Malods has been allotted a seat Malods in the first round of counseling as well as in the second round of counseling Malods. Second round of counseling allotment, your Lordships will find it at annexure K1.
What is category 2A?
My apologies, Malods.
What is category 2A?
2A is Malods religion, Malods. Kumbara religion. Category, OBC.
OBC.
OBC category.
So caste. Caste.
Caste.
quota.
Yes.
The caste.
What is yours?
KA, Malods.
We are not the answering party. The KA is the answering party.
Notice.
No, Your Lordship, issue notice, madam. Monday, Your Lordship, my
Notice it on Tuesday.
Please.
Malods, as it stands, Malods, they have allotted a seat. We have received a call saying we are going to cancel it and allot it to somebody else. Just a call, Malods. No endorsement is issued to us. That is why, Malods, we have come before your Lordship.
Normally, we don't call him. According to me, my lord, checked up. They have given a provisional admission.
This appears to be a mission in hurry.
Malods, when I heard the Malods, they say it seems to be a sort of a mischief trying to be played on the petitioner.
Notice returnable on
Monday, Malods, may kindly be.
Monday.
Yes, Malods.
Monday.
Malods, learn.
And Advocate Mr. Ramesh, as well as learned additional government advocate Mr. Hegde, we have service of notice on behalf of Karnataka Examination Authority and the state government respectively.
Malods, respond number 3, Malods, respond number 4 at this stage may not be required, Malods.
Who is number 4?
Is the institution, Malods. KEA, my lords, if it confirms my admission, my lords, that notice may not be required. To that extent, my lords, on Monday.
Where is that institution? In Bangalore?
In Bangalore. Itself.
Bangalore.
Serve them.
And summons if I would.
Rest of
Permitted.
the respondents shall be served, for with the end summons is permitted.
Yes, Monday, correct.
Returnable on Monday. Monday, that is 23rd.
Please.
This is number 2. So Kutegoda K.
Last occasion, my lord said direct
petition.
independent assessment be conducted, my lord. Yes.
Okay. Lords. Lords, but the individual assessment as to the strength and the motion is not given as per the apex court's order, my lords, where individual assessment as far so far as strength and the movement of the hands are concerned.
There. However, sentence is there, however. That
Lords,
is a
if
qualitative assessment.
if I may read, my lords.
However, read that, the last line, last paragraph.
line, however.
However. The petitioner was a student, write down. The petitioner was a student who, by filing this petition in Article 226 of the Constitution, prayed to set aside the undated list of UG NEET PWD candidates, P capital, W small, D capital. PWD candidates eligibility issued by respondent number 2, the Karnataka Examination Authority, into bracket KEA. It is further paid, it was further paid to direct the respondents to consider the candidature of the petitioner under the persons with disability, into bracket PWD quota, for admission to MBBS course by taking into consideration the disability certificate issued by the competent medical court, medical board, and to allot the MBBS seat to the petitioner in general merit PWD quota. Also was the prayer to direct the respondents to conduct medical test of the petitioner in order to assess the degree of physical disability by another independent medical board. Full stop. When the petition came up for consideration on 11/9/24 paragraph, 11/9/24, order was passed by the court providing for renewed examination of the petitioner. about his functional disability, including for assessment of qualitative aspect of disability. Paragraph, the said order is extracted here and in its relevant part. In paragraph 2, 3, 2 onwards. To 4.2. Then 6 onwards to, it was further observed, then 6 onwards to paragraph 10, full stop. Today when the petition came up for consideration, I'm reporting. Today when the petition came up for consideration, learned, you produced, learned additional government advocate, sir. Sudev Hegde stated that as per the directions of the court, the petitioner student was examined by the medical board comprising of 5 expert doctors. First of the report dated 19/9/24 was submitted. Examination report dated 19/9/24 was submitted in a sealed cover. Also, the sealed cover was permitted to be opened in the presence of learned advocates for both the sides. Full stop. The report of team of doctors comprising of Dr. पूरा नाम लिख लेना, Kempraj T, Medical Superintendent, Browning and Lady Curzon Hospital, Dr. K.G. Gopal Krishna, so and so and so. Recorded the following findings. Then quote the bracketed part, pencil bracketed part. Following finding in the report. Full stop. The above finding clearly shows that the petitioner is found to have 80% disability, 80% locomotive disability. It is stated by the team of expert doctors that, comma, then inverted comma. However, he has total absence of prehensile, PREHENSILE functions of hand on both the sides. Inverted comma, the petitioner is not treated eligible to pursue the medical course as per the expert opinion which assesses the petitioner for its quantitative and qualitative disability. Full stop. In view of the above, comma, taking the copy of the aforesaid report on record, comma, it has to be held that no relief could be granted to the petitioner as he is found not eligible to pursue the MBBS course. Petition accordingly stands dismissed.
Grateful. Plus, this will not come in my way of eligibility of.
To give copy, one copy to the council and the copy to for placement on it.
I'm grateful.
Yes. List 1, content matters. Seal number 1, Sadananda G. Shastri.
Like to appear for the complainant in this matter, Lord. Challenging the contempt action of the respondent at Annexure A, my lord. The case revolves around the short compass of the fact that, my lord, the petitioner in the year 2012, my lord, he forms a layout known as Golden Pearl Residency. My lord.
Notice written on 29th of October.
Wait.
To dispose seal number 3, Mr. Nataraj T. Seal number 3, Mr. Nataraj.
Keep there, 2/3.
Number 4, Mr. Raghavendra C.
Beg to appear for the complaint. No, the direction for determination of compensation within a stipulated period of 3 months. It's not done by the respondent.
Notice it on 29th of October.
System number 5. The civil.
Council. Page 36, my lord, lordship would find. This honorable court, my lord, had directed that in the light of conviction of the respondent, my lord, for murder, he was disqualified as a, my lord, the secretary, and therefore, my lord, had passed an interim direction. At page 37, my lord, your lordship would find. At page 38, my lord, the operative portion that he shall not act or claim as secretary. Despite this, my lord, the accused, my lord, gives a power of attorney as a secretary to another person, my lord, and starts, my lord, attending the case of the society, my lord, lordship may permit us, my lord, to just pass on copies of the power of attorney, my lord, which we have obtained. Despite the interim order, my lord, he claims as secretary. At page 38, my lord, your lordship would find the interim order which has been continued, my lord, and is operative even till today.
Interim order.
Please, madam. That interim order has continued, my lord, till today, my lord. Despite this, my lord, your lordship is not, after having been convicted, not gives a power of attorney as a secretary, my lord, if I may just pass on, my lord. In direct contravention of the order, my lord, of the, on to the, this honorable court, my lord, because.
What is this?
Please, my lord, the power of attorney, my lord, which is given. But because he was convicted for murder, but he stands disqualified not as a member of the society. He claims as general secretary of the society, but not despite the conviction being there. The lordship would not note that has been taken not in to note at page 37 or at the bottom of the order. Your lordship will have a look at the general power of attorney which is given in February 2024, after the order. Despite having notice of it, he was on caveat. Your lordship turned to the second page of the power of attorney. Therefore, he claims he is the secretary and acts on behalf of the society.
Heard learned advocate Mr. So-and-so for the complainant. The order which is brought under the contempt jurisdiction of this court by invoking the provisions of contempt of court section 1971 is dated 4th January 2024. Full stop. The order is an interim order, the relevant part of which reads as under. Then page 30 bracketed portion to be quoted. Full stop. Main writ petition is pending. The returnable date was 9/1/24. The interim relief which is granted, interim arrangement which is ordered, is without prejudice to the rights and contents of parties to operate till the next date of hearing, whereby it is provided that respondent 3 shall not claim or function as general secretary of respondent 1 society. It is society.
Society. Society, my lord, it's a society.
Full stop.
Is having
Learned
education
advocate for
institution.
the complaint would submit that despite the above order, the respondent concerned is attempting to function as general secretary. Full stop. The order is interim order. Full stop. By its very nature, it does not crystallize the rights of the parties, finally. Full stop. The main proceedings are pending at large before learning single judge to be considered on merits. Full stop. When the order is interim order and the rights of the parties are yet to be finally decided in the writ petition, the court is not inclined to exercise the contempt jurisdiction to entertain the present petition. Full stop. The petition is permitted to raise all the contentions to learn a single judge and also seek appropriate relief in relation to in the context of the allegations raised in this petition to work out his rights and remedies in the current proceedings. Accordingly, present proceedings are not entertained. Right. Yes, next.
Number 6, Chamar Korea.
Defiance minutes of the interim order of stay of investigation. The accused police proceed to file a charge sheet, my lords. This charge sheet results in summons being issued, cognizance being taken. At page 22, my lords, is the order of stay of investigation.
Lords, there's another
Despite being
order
a-
passed by this honorable court wherein there's a direction, my lords, to complete the investigation. There's another order, my lords. Based on that, The charge sheet
Page
has been-
92, we have produced that order as well, my lords. That order is dated 30th of August 23, my lords. Stay of the investigation is dated 21st of September 23.
The final order is passed requiring the authority to complete the investigation.
But after that, my lords, subsequent to that, my lords, is the order passed staying the investigation. My submission is, after the order was passed staying the investigation, 2 hearing dates went by, my lords. My lords, may kindly turn to page 85. 16/1/24 and 18/1/24, the charge sheet dates filed. The subsequent 2 hearing dates, my lords, at page 29. The police ought to have, the investigating officer ought to have sought a clarification as to whether the investigation should be continued or, my lords, it has to be stayed as per the order passed. But the earlier order was, my lords, direct with the direction for a speedy investigation. But subsequently, order on merits of the matter, my lords, required the police not to proceed with the investigation. Ms. Para. Ms. Contempt order, we have sought for stay of the investigation in the crime registered against us, my lords. In the same case, they had earlier sought, my lords, that the investigation be speeded up.
Lords, this petition.
In the
was
same crime, my lords.
Where the
Page-
final order has been passed, the petitioner alleges that the complainant has forged the certificates for obtaining the tender. Parties are
Same
different.
parties, my lords. Please, my lords. I was the accused in the said FIR. And, my lords, in the WP, my lords, that is the complainant in the writ petition. That is the complainant in the same FIR. So first, this honorable court,
Yes.
same, my lords. They ought to have sought a clarification. The resultant the consequences that follow, my lords, herein are, despite there being a stay of investigation and also an earlier order, my lords, of for a moment, paragraph 15 of my petition may kindly be seen. My submission is this. 2 hearing dates went by before they filed the charge sheet in the 482 petition. And they have appeared, my lords. They have not stated in the said court that granted a stay that there is another order. They have not stated that there is another order directing us to speed up the investigation. But my submission is there, no doubt, but there was an order to speed up the investigation, not on the merits, my lords. They ought to have at least sought a clarification from either from the writ court or in this court itself. And we were not a party in these proceedings in writ petition, my lords. We were aware of the petition filed, but we were not a party. We were not aware of what exactly was the order. And we even mentioned that in our petition, that there is an order passed, but we were not a party to it. But they ought to have at least sought a clarification stating that the Honorable Writ Court has directed a speedy investigation. This Honorable Court has granted a my submit, must kindly consider this. My grievance doesn't remain anyway. Now cognizance was taken. But even in fact, the order, the in. To investigate, that was there for a speed investigation. Then the police are notified, kindly see, the order itself, the copy was served on the order itself indicates that the stay order, page number 24 may kindly be seen, my the stay order is communicated to the police and also to the learned magistrate. Despite a stay, we were compelled to appear before the jurisdictional magistrate, and we therein submitted that despite there being a stay, the police have proceeded to investigate the matter, file a charge sheet. And the least the police, the contemners, which what they could have done is withdraw or desist from filing the charge sheet, but perhaps complete the investigation. At least that is what could have been expected of them.
On page 24, my lords, it clearly indicates we were served on 3/10/2023. of Page 24, my lords, the station officer receives this copy. Please.
The challenge, my submission is, it would send a signal to the police that in defiance of this stay order, they could still investigate the matter and they could proceed to file the charge sheet leading to. So contentions urged herein, my lords, may kindly permit us to urge the contentions made herein, my lords, may kindly permit us to urge in the 482 court as well on the merit, because we say that. Please. 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 Black.
Number 7, kept back matter. Still number 8. It's a PL Ashwatappa.
With your lordship's kind permission, my lord. With your lordship's kind permission. Lord, I,
Petitioner's counsel, my lord.
your lordship's kind permission.
Still number 9. Srimati Purnima S.
Please, my lords, for the petitioners. Agreed by the impugned hours passed by Lok Adalat and the subsequent sale deeds, my lord, the petitioner before this honorable court. Lordship, lands are number 96, measuring 237 acres in Takkalaki Tanda, had been granted to the Tanda people by the then Maharaja of Aundh, a princely state in the British India, my lord. So on grant, my lord, the names of the Mukhias were entered in the record of rights. It starts from Annex A, my lord, starts from page 102. Lordship, in the translated copies are at page 118. So when the record of rights continued in the name of Mukhya held the entire land for the people of Tanda. On his demise, his family members tried to create hissas. After coming to know of that, my lord, there was a representative suit filed by the elders of Tanda in OS number 149 of 82. Lord, Annexer B to the writ petition. Lord, starts from page number 147 onwards. The prayers in the suit, my lord, they will also may kindly find it at page number 128.
For a minute, my lord, your lordships to, may I take your lordships to page 128. My lord, may I pray for interim order because the land has been acquired and the private disbursements are sold illegally based on that. I'll sought for interim direction also. In fact, my lord, these kind of matters are covered by the judgments because Lokatara awards by playing fraud. They were not the parties before the representative suit. And there is a decree that it was declared. Please. No, my lord. May I pray for a specific date, my lord?
Number 10. Mr.
May I request
Srinivas?
your lordships to have it on 7th. Obliged.
Number 10.
Petitioner in this case. Lord, the petitioner in the instant case have called in question the notification dated 25/2024, wherein, Lord, the government have made a policy, Lord, decision that reservation should be provided in outsource employment also, Lord. The Lordship may kindly come to page number 25, which is at annexure A, Lord. In tender, my lord, they call for a tender for providing outsource drivers and everything, lord, other staffs, D group staffs. Now, my lord, in that, the government wanted to implement the reservation policy, my lord. Challenging that, I am before your lordship, my lord, because it violates Article 15, my lord. Reservation applies only in case of state government employment, my lord. Though we, yes, my lord. But the rest of the things are annexure B series is, my lord, the tender notification which stipulates the implementation of notification dated annexure A, my lord. In the tender conditions, they have made it as a tender condition itself in the tender.
It is.
Green bench matter, seal number 11, Mr. Srinivas Kane.
For the petitioner. That petitioner is the owner of the land, revenue land, Millard. And where, in which the minerals are available, for which he has obtained the mining lease in the year 1999. Kindly for a moment, synopsis may kindly be seen. 1999, 2/11/1999, it was granted mining lease. And to 2011/2099 lease deed was executed, but it was not registered due to some payment of stamp duty, my lord. Then director of registrar has written a letter, my lord, clarifying the matter and directed to register the release date. It was not done, my lord. Lord, in the year two, but so, yeah, he has commenced the mining and was doing mining activities. And but mining lease deed was not executed in his favor till 2013, my lord. In 2013, he approached this honorable court, my lord. Kindly turn to annexure H, my lord. Annexure J1, my lord, page 77. This honorable court, my lord, page 77, annexure J1. This honorable court has directed the state government to execute the lease deed within a period of 8 weeks from that date, my lord. But it was not done, my lord. Subsequently, my lord, it was pending before the state government. Subsequently, there was an amendment to the Karnataka Land Revenue Act, where where the land is, other than the agriculture purpose, if it used, it has to obtain the conversion order. And it came, and in 2015, it was amended. Due to that, my lord, this was not executed. Again, this petitioner approached this honorable court, my lord, annexure L. Three times, my lord, yes, annexure K also, my lord, this honorable court, with regarding the conversion of land, he approached. Was direction was given. Meanwhile, my lord, the lease executed earlier, 20 years has been, my lord, expired, my lord. In the meanwhile, my lord, it was expired. My lord, as per the amended provision of section 8A6, my lord, he is entitled to for deemed conversion of 50 years, my lord. But by way of annexure M, my lord, at page 86, translated copy at 87, it is produced. My lord, this deed has been, mining lease has been cancelled due to, my lord, non-registration of lease deed as well as non-conversion of the land. During this notification has issued during Corona period, my lord. But now, my lord, I have submitted a memorandum, my lord, at annexure P, page 90, to consider my request, my lord. Representation has been, I'm seeking writ of mandamus, apart from quashing of annexure M at page 87. Let them consider my request, my lord, and annexure, as for annexure P, my lord, at page 90. Because though it is executed earlier, lease deed was signed by the authorities, it was not registered. And for which state government issued notification along with other 10 persons to execute the lease deed, which has been produced by me at page 68, annexure H, my lord. Translated copy at 70. But out of 11 members, 5 members have been executed. Our lease deed has not been re-executed by the state government. It's a patta land owned by the petitioner. Yes, it has to be converted. Because of non-registration of lease deed, my lord, it was not it was converted from agriculture to non-agriculture purpose. It has to be
So far
converted.
not converted. It is
Not
no-
converted. Ma'am. It's not converted.
It is not converted, not it. Because by the meantime, it is expired. Lease deed term 20 years has expired.
You enjoyed it for 21 years.
Oh, my lord, we have not enjoyed.
Right.
It was stopped a long back. Long back. We have not, after issue of the letter by this department in the year 2015, after amendment to the KLR Act, I have completely stopped. We are not utilizing it. In fact, there is a provision, my lord, under KLR Act 95, my lord. It has to be deemed conversion has to be granted. That was urged by me in earlier petition before this court, my lord. But when the doing pendency of that petition, my application was rejected by the deputy commissioner. I'm entitled for deemed extension of 50 years, my lord.
Lord, may I make one submission?
Where is it? Notification 11/8/2020. Page.
Next year,
My lord, that is at page 87, next year M.
11, yes.
page 87, my lord. 86 beginning Kannada, translated copy 87. May I read, my lord? 11/8/2020. Notification number so and so. As per approval dated 3/6/1999, mining lease number 2257 was granted to so petitioner Yellappa Lakshmappa on 2/11/1999 and executed on 20/11/1999. However, since the lessee did not proceed to register the lease deed as per rule 31(2) of the Mineral Concession Rules and under the Karnataka Stamp Duty Act 1957 and did not submit the land conversion order within the prescribed period, Section 80A of Amended Act 2015 has ruled out that the following mineral lease has been ineligible for extension of the lease term. None, this has been issued, my lord, without hearing and without issuing any notice also, my lord.
My lord. My lord, paragraph 3 may be seen for a minute, my lord. The paragraph 3 of the writ petition, internal page 8, the first sentence. My lord, after execution of the above mining lease deed by the state government, the same was presented for registration. My lord, now, my lord, the stamp duty that is paid, the lease is for a period of 20 years. They pay a stamp duty for only 1 year. My lord, and even if they had paid, my lord, within 4 months from the date of, my lord, signing the lease deed, that should have been registered as per section 71 of the Stamp Act. That has not been done.
No, for which clarification has been given by the district registrar at page annexure F, my lord. He says whatever the 1 year fees stamp duty is paid by the petitioner is correct. Subsequently, they have issued an endorsement to that effect. And they have extended the time of 30 days also. In spite of it, it was not registered.
Or learned advocate Mr. So and so and so. For the petitioner and learned additional government. For the respondent state who appeared to assist the court upon service of copy of the petition in advance. The petitioner raised to set aside notification dated 11/8/2020 of the state government. Whereby the lease of the petitioner number 2257 is treated as ineligible for extension of the term. The said lease was granted to
Annexure M.
one Mr. Yalappa Lakshmanappa Nyam NYM Nyam Godar on 2/11/1990. It is the case of the, it is the say of the petitioner that since the said lessee did not proceed to register the lease deed as per Rule 31(2) of the Mineral Concession Rules 1960. Under the Karnataka Stamp Duty Act 1957 and did not submit the land conversion order within the prescribed period. Under section 8 capital A of the MMDR Amendment Act 2015. The mining lease is treated to be ineligible. The facts show that paragraph. Mining leave was granted for a period of 20 years from 20th/11/1999 in respect of revenue land measuring 4.86 hectares in survey number 526/2/1 and survey number 526/2/2 of Yadwad village, Kauja Lagi, KOUJ, Kauja Lagi Obli, Kokak Taluka, Belgavi district. It is the case of the petitioner that that it is entitled to deemed extension of 50 years under the rules, and that the state government has issued notification dated 11/8/2020 arbitrarily and without issuing any notice to the petitioner. Lease period paragraph expired in the year 2019. The petition was filed. Petition is filed in 2014, 2024. In addition to the above aspect, it could be immediately noticed from the record that representation of the petition dated 21/3/24 is pending before the Principal Secretary to Government, Department of Commerce and Industry, NSME and Mines into bracket is pending and has remained undecided. In the totality of facts and circumstances, this petition is disposed of by directing the competent authority of the respondent to consider the representation dated 21/3/24 of the petitioner already made and pending to decide the same in accordance with law strictly on merits within a period of 8 weeks from today. petition is accordingly not entertained for its prayers.
Obligement.
Writ appeal matters, still number 12, Mr. Vedamurthy MV.
I appear for
Yes, ma'am.
appearance in this case, my lords.
Appear for appellant.
Yes, my lords, we have challenged the order of the learned single judge passed in writ petition number 15164 of 23, my lords. There is a caveat filed, my lords. The same matter.
My lord, because of this appeal, contempt though filed, my lord, after filing contempt, this writ appeal is filed. Because of that, contempt is not being proceeded. They are saying the writ appeal is filed, and on that ground, contempt is not being proceeded. These are all persons, my lord, working in the Kaya board. 17 persons were regularized. Out of them, my lord, 4 persons were given higher pay scale and 2 revisions were given. Thereby, there was a discrimination. Learned single judge allowed and held that the discrimination, and therefore pay scale as granted to others in the same order of regulation has to be granted to the present respondents, my lord, who are the petitioners. There is no error in the order of the court.
My lords, the respondents were taken on job on honorarium basis, my lords, and the company doesn't have the C&R rules, my lords. So this matter, the C&R rules doesn't, the company doesn't have the C&R rules, my lords.
The question is not that. They have regularized our services, my lord, in 2011. From 2014, for 4 persons, they wanted to give higher pay scale, my lord. Again, in 2016, they revised it. Thereby, they granted 20,000 something, whereas we were stagnating in 5,000 something. Therefore, court held, your lordship, in persons of judicial order. Division bench order of this honorable court directed regularization. Accordingly, we have been regularized in 2011, but only 4 of them were given higher pay scale. That is all the simple case.
Release to notice it on 7th September, 7th November.
Case number 13, Mr. B.V. Patil.
My lords, for appellants.
There is a delay of 342 days. Notice
Please.
it on 8th November.
Case number 14,
Lord, I
Appeal
appear
by
for
state.
the appellant. My lord, there's a delay of 491 days, my lord.
So notice it on 7th
Obligement.
October.
Number 15, Mr. MC Basuraj.
For appellant, my lord, there is delay of 415 days in filing this appeal, my lord. The appellant was working as a employee with the respondent corporation, my lord. After dismissal, he is out of employment. Due to financial difficulties, he could not approach this honorable court to continue the litigation. Award of the labor court has been set aside by the learned single judge, in which the order of reinstatement has been passed by the labor court against the corporation to reinstate him with continuity of service by withholding 3 annual increments, my lord. Case of the appellant is that when he was working with the respondent employer, he suffered a disability. Due to disability, he has submitted an application before the corporation seeking to relieve him on VRS. But the respondent corporation, without relieving him on VRS, has dismissed him from the service. Even then also his disability was not recovered. Therefore, he was not in a position to discharge the duty of the assistant artisan. Nature of work was in the nature of repairing the buses, heavy buses. Therefore, he was not in a position to discharge that duty.
For 7 days. 10 days.
Even assuming that charges held proved, the labor court has wider jurisdiction under section 11A to more limited relief, my lord. Accordingly, limited relief was granted to the employee.
You have given some voluntary retirement notice.
I have submitted an application to seeking voluntary retirement.
Where is that?
My lord, there is a reference at, in the award also, page. In page 8, my lord, main page 82, page number 82, my lord. There is a reference. It is an undisputed fact that my lord, he submitted an application seeking VRS, but instead of considering his application, has dismissed him from the service. Moreover, the labor court has wider jurisdiction to more limited relief, my lord. Accordingly, order to reinstate him with continuity of service by withholding 3 annual increments. Even back wages also has not been awarded. Limited relief has been awarded. Page number 82.
You serve copy to
Please,
counsel for the State Road Transport Corporation.
please.
Learned advocate may serve copy of this writ appeal to the counsel for KSRTC, who shall appear on the next date and assist the court. Send over to 30th September.
30th September. This is still number 16. Mr. Rajendra VG. Delay of 628 days.
Delay.
Grantees appeal before the, and learned single judge, even though there is in the, both the AC and DC. There is a delay of 628 days. The reasons, my lord, in fact, they are illiterate. Grantees appeal, this paragraph.
So sorry, dismissed. There is nothing.
No, no, Lakshmi, kindly, may I request me, the page 85 may be kindly be seen. The translated copy, reasons here. Even there is a clear finding by the authority, that is the Assistant Commissioner. Respondent number 2. This ought to have been noticed by the learned judge, learned single judge. Here, from the statements available on record, may kindly, Lakshmi kindly appreciate this point for consideration. it is revealed that the petitioner belongs to Bowie caste. His father also belongs to Bowie caste. Since the petitioner informed that this land has been granted temporarily, since no information about the grant is available in the index or RR record, by considering the petitioner's statement and the defendant's written statement, it is confirmed that the land was granted. Here, my lord, why, according to Kannada version, ದಾಖಲೆಗಳು ಯಾವ ಮಾಹಿತಿಯೂ ದೊರೆಯುತ್ತಿಲ್ಲವೆಂದ there is no documents is for the place before the assistant commissioner, third respondent. Even though both the assistant commissioner and the deputy commissioner without this points has been not been urged. That's what I try to pursue, my lord. Here, this is a granting appeal. It is undisputed. It is not for an upset price. It is a grant. There is no document is for there is no document is placed before the revenue authorities. That's what I try to pursue, my lord. Your Lordship, kindly, in the absence of the document, they ought not to have the opinion. In fact, my lord, this was the grant in 1953-54. And later, my lord, your Lordship, kindly, learned single judge, your may request, my lord, page 13, 13, my lord. That is the order of the learned single judge. May I request, your Lordship, kindly, what I try to point out, this after the learned single judge ought to have been taken note, whatever the before the AC, no records are available for having paid the upset price or whatever may be the that arrive a conclusion by the learned AC and the deputy commissioner, both the authorities and both the first respondent as well as the second respondent before the learned single judge. This point ought to have been taken by the learned single judge. That is my try to pursue on this point. Here, you will kindly the on appreciation of the material and specifically on the ground that the subject land is granted for an upset price, the petition again for here there is nothing to show on documents before the revenue authorities, both the deputy commissioner as well as the assistant commissioner. That's why page 85 I brought to your Lordship kind consideration, and also I try to pursue and in the Kannada version is very clear. ಕಡತದಲ್ಲಿ ಲಭ್ಯ ಇರುವ ಹೇಳಿಕೆಗಳಿಂದ ಅರ್ಜಿದಾರರು ದಟ್ ಇದೆ ಇದು ಅರ್ಜಿದಾರರಿಗೆ ಹಂಗಾಮಿಯಾಗಿ ಮಂಜೂರಾಗಿದೆ ಎಂದು ಅರ್ಜಿದಾರ ತಿಳಿಸಿರೋದ್ರಿಂದ ಮಂಜೂರಿ ಬಗ್ಗೆ ಇಂಡೆಕ್ಸ್ ದಾಖಲೆಗಳಲ್ಲಿ ಯಾವ ಮಾಹಿತಿಯೂ ದೊರೆಯುತ್ತಿಲ್ಲವಾದರೆ.
Yes, next.
Number 18.
I appear for appellant, my lord. In this case, we have challenged the order of the learned single judgment in WP 40/2024, wherein the learned judge has directed us to pay the 1,580 per square foot in respect of the grant of the land. Of course, the earlier to it, the grant was made as per Annexure B, my lord. 2,995 square foot has been granted, and the remaining extent was due to be registered in my favor, though it was granted. But unfortunately, the demanding 1,500 feet per square foot, which is highly excessive. That is my humble submission. Though the learned judge has quashed the illegal notice dated 28/11/2023, my lord. And of course, it's not justified in passing the order to pay the amount, because earlier grant was made 2,995 square foot for the amount of 1,075 per square foot. And of course, subsequently, the amount of rupees 380 was enhanced. And in respect of it, this appellant has challenged before the on this honorable court, WP number 14,066, 2011. The learned judge has directed to deposit the remaining amount of 3,41,309, which was deposited. So far, that extent is confined only to 265 per 90 square foot, my lord. So far as regarding the remaining extent, the meeting was conducted under the presidency of the TUDA, and it has enhanced the amount of 1,580 rupees, my lord. That is illegal. Therefore, it has to be minimized because he is a retired person, class 4 employee, he is unable to afford to pay that much of amount. That is what we are aggrieved by the judgment and order of this honorable court. In the WP 8003 2020, my lord. Therefore, mind kindly consider this aspect is concerned. And we have made out a reasonable grounds so for considering, because he is the loser of the valuable house and site situated at out of the city at Tumkur. Therefore, there was, now it is escalated, price has been escalated. But even at that time, during the time of the formation of the overbridge, railway overbridge, even then also the price was very high. So therefore, taking into overall situation, the price of rupees 300 may be fixed, or at least it may be fixed at 500 rupees per square foot. That is my humble submission. Therefore, this aspect has not been considered by the learned single judge, and therefore the treat of may kindly be allowed here.
Heard learned advocate Mr. So appeared online to make submissions, as well as learned additional government advocate Ms. Leela Akbar, who assisted the court upon service of copy of the PT, copy of the writ appeal in advance. The challenge in this writ appeal is directed against judgment and order dated 8th April 2024. Passed in common in writ petition number 40 of 2024 and writ petition number 8003 of 2020. Insofar as the said common judgment and order related to writ petition number 8003 of 2020. Full stop. The prayer in the petition was to set aside order dated 11/2/2020 passed by this number 2. Lumpur, Dispon 2- the Lumpur Urban Development Authority, Review Commissioner. It was next prayed to direct the respondents to enforce the order of allotment of site dated 30/10/2010 in favor of the petition. As per the said annexure B, the petitioner Sri C.B. Narasimhaiah son of Chikkarangaiah was one of the allotee amongst 7 other allottees. The petitioner came to be allotted site at measuring 2,955 square feet. In capacity of a person who had lost his house. The amount payable towards allotment was rupees 5,17,016. Subsequently, it appears that subsequently the petitioner requested to distribute the space, additional space, abutting the site number 1425 as extension of his home. Full stop. The request of the petitioner was placed before the competent authority. Full stop. A meeting took place. The request was considered. In respect of the site which was numbered as site number 1425 capital A. It was observed, paragraph, in the impugned order dated, impugned communication dated 11/2/2020, having noted the facts as above, it was observed that the petitioner had encroached the area to the extent of 104.45 square meter, equivalent to 1124 square feet, which was an excess area. Therefore, it was decided to charge at the rate of ₹1580 per square meter in respect of the encroached area, and to place the case before the government. Full stop. While entertaining and considering the challenge, learned single judge has justified the demand for additional amount at the rate of ₹1580 per square meter. Notice was issued, it was recorded by learned single judge, dated 28/11/2023, calling upon the petitioner to ensure that the construction is according to the sanction plan and commencement certificate was duly obtained. Paragraph. While dismissing the petition, while allowing the petition, from a learned single judge permitted the petitioner 3 months' time to pay the additional price for the additional extent of occupation as per communication dated 28/11/23. While disposing of the petition. Full stop. Following reasons, paragraph, weighed with learned single judge. Extracting the relevant part from paragraph 5 of the order. Then at page 23, bracketed portion. However, as regards the demand of price, demand must be constituted reasonable. It is rightly observed by learned single judge that petitioner who has occupied the additional area cannot assert as a matter of right that he must be given the benefit of this additional area at the original price. When the additional and excess area was occupied and was claimed by the petitioner, separate compensation for the said part ought to have been separate amount. This said part what is required to be paid to the petitioner. Full stop. Learn a single judge has only granted 3 months time to pay the amount. Paragraph. The impugned order is impugned judgment in order is eminently just. Impugned judgment in order on a single judge, eminently just, legal and proper. No interference is called for. The appeal is dismissed as meritless.
Right. Number 19. VHK.
Appearing for the state, my lord.
It's a dispute between son and father, my lord. Father had filed a petition for eviction of son from the residential premises by invoking the provisions of Senior Citizens Act, my lord. And the Assistant Commissioner passed the order of eviction, my lord. Being aggrieved by the said order of eviction, the daughter-in-law filed a writ petition. The son also filed a writ petition, my lord. And both of them have filed writ appeals before this honorable court. In the writ appeal that is filed by the daughter-in-law, my lord, the matter has been referred to mediation, and mediation sessions are going on. Therefore, this matter may also be tagged along with that writ appeal, my lord.
What is referred to mediation?
Writ appeal number 1186 of 2024.
Dispute between the children and the parent, my lord.
1186 or 21. It was stated by
24.
learned advocate with so and so in course of the for the petitioner, in course of the hearing. Writ petition number 1186 of 21.
2024.
2024, which involves the facet of the very controversy between the family members, is referred to mediation. He therefore requested that the present petition may also be referred to be taken up for mediation.
The parties in this writ appeal, my lord, are already in mediation, my lord. Therefore, this matter may not be referred to mediation.
Along with the said petition. Yes, full stop. Since the parties are already engaged in the mediation, the registry may forward the papers of the present petition to the learned mediator who is handling the mediation in the connected matter.
My lord, the matter is posted on the 25th month.
The petition may be listed after 8 weeks.
My lord, sorry, my lord, 1 minute, my lord, the matter.
May make one request.
One minute, my lord. I appear for the respondent number 2.
Appeal that is filed by the daughter-in-law, my lord, this honorable court has granted an order of status quo. In this matter also, the very same order may be extended.
My lord, may kindly hear me for 1 minute.
Go to mediation.
Yes.
Since the parties are in mediation, no action in precipitation shall be taken by any of the parties.
There's a caveat who's online, my lord. The caveat is.
I appear for the respondent number 2. My lord, I appear for the respondent. My lord, the matter.
Starting. Yes, Mr.
My lord, the matters are slated to be posted before this court on the 25th. The other connected matters posted before this court on the 25th. Only one other aspect, my lords. My only request is that this matter can be tagged along with that so that both matters can come up on 25th before this court. It's coming up on 25th before this court.
So it is sent for mediation.
My lord, the problem is that the date given to appear before, my lord, this honorable court has posted the matter for final hearing on 25th. Matter is going on in mediation, sessions have happened. All the parties are before the mediator. But the date given by this court in the connected matter is 25th. So I'm saying, please connect this matter also to 25th itself. Then 25th matter will be extended.
Before the High Court Mediation Center.
Yes, ma'am.
Yes.
First. It will be open for the parties to request the High Court Mediation Center to expedite the mediation. Since it involves the family dispute.
Great.
Number 20 urgent, seal number 21 to Suyo Girale.
For complainant's advocate. Not the government has filed an affidavit saying, my lord, symbolic charge has been given. There's a temple, my lord, administration. There is a clear direction, my lord, the entire administration has to be handed over.
Additional affidavit
And
was
their
filed.
affidavit is, my lord, contempt, that itself is a contempt according to me, my lord. It is contrary to the direction given by this honorable court. The affidavit, my lord, kindly see, my lord, the contents of the affidavit. Yes, my lord, at page 5. Administration of the. Yes, my lord. Is handed over? No, they have not handed over, my lord. That is what they say. Symbolically, they have given. My lord, kindly see page 4 of the affidavit. Yeah, I respectfully submit that until the rights of the third party, that is B.V. Ramesh, are adjudicated, the same have to be attained finality. That entire charge with regard to the availability of the case, valuability, and the case of Hundi are directed to be kept in the safe custody. So they are, therefore, my lord, they are not giving. The direction is, my lord, clear. It is at, my lord, page 2. Respondents are directed to hand over the administration to Sri Shamanna, second petitioner in WP number so and so. Lord, the person now who are claiming to be hereditary, they are also one of the hereditary trustees, are also party to the writ petition, my lord. They are, my lord, they have not challenged the writ order, one thing. Number 2, my lord, here the writ appeal is dismissed. And they were aware of the claim of somebody else. And the court has cautiously directed them to approach and redress their grievance elsewhere. Now they are, my lord, claiming their right somewhere and matter is pending. Merely because that matter is pending, that will that will not come in the way of, my lord,
Which matter is pending?
My lord, in Dharmika Parishad, some, my lord, the other petitioner in the connected matter, they filed their claim saying we are also hereditary trustees. Our right may be adjudicated. Lord, why when the administration was taken over from me, my lord, there was no claim or anything. It was completely, my lord, taken over from my hand by a valid, my lord, Mahajar and, my lord, inventory. Now they are simply, they have given a letter and saying we are handing over the charge. My lord, my contention is this, my lord. The manner in which the administration was taken over by the administrator, in the same manner, my lord, they should have been put it back.
Your Lordship, may kindly see the order sheet, Your Lordship, at page 28.
No, we have already passed an order on 29/5/24.
Yes, Your Lordship. What
The order is clear and explicit.
Yes, yes, Your Lordship.
Unless you comply this order.
No, we have,
and with the original direction, we call the person here.
no, we have complied with the order, Your Lordship.
What? No.
No, we have handed over the keys. Your
State
Lordship,
that
may
it is-
kindly see annexure R2. R2 at page 31, Your Lordship, is the.
It is said that, and in order that the handing over becomes meaningful. Meaningful, yes. Has to accompanied by handing over of all movables,
Yes, sir.
cash if any, accounts, ornaments, and other items, including keys and accounts, which are physically available, which was taken over in the year 19, which was
Yes, my lord.
taken over in the year 2015.
Your Lordship.
So all those things you
Yes,
give,
yes.
contrary
We
to
have
the
already
this
given, Your
affidavit
Lordship.
runs contrary to your lordship's order.
If I may,
This para 7
if I
of
may
the
submit,
affidavit.
Your Lordship, at page 31, Your Lordship.
Very, your compliance.
Yes, Your Lordship, compliance,
Dated-
additional
dated
affidavit.
Compliance. has
Additional
been dated-
compliance affidavit, Your Lordship.
Which date? 8/7.
8/7.
8/7. Para 7 is contrary to your lordship's direction. Para 7 is contrary to the directions, 6 and 7. This affidavit is filed after the orders were passed.
Page 31, Your Lordship. And the translation is at 34 and 35, Your Lordship.
So this is absolutely contrary. Keys of the. Completely. Taluk to hand over the charge of temple, except keys of the hundi and ornaments.
Yes, sir. My Lord, what has
We
happened
do
is.
not know. You challenge, you will get modified,
No, my
or
lord,
else.
my lord, if your lordship could see the directions of the learned single judge also,
Okay.
the other part of the order is
The petitioner in WP number, there are two writ petitions where the orders have been passed. In the common order passed in two writ petitions. Now, the other writ petition, it says, petitioners in WP number 177/2018 shall be at liberty to work out their remedies in appropriate forum. So the only direction that was given, Your Lordship, the ornaments which are on the key to the hundi have been kept in safe custody. It is not that they are not handed over. And also direction was given that whenever there is a festival or a festivities in the temple, they can draw it, use it and deposit until this rights of the other Wahid Wardar who can be disposed of.
Let us see where is the original directions.
Yes.
It is there in the same affidavit, Lord, page 29, 28 and 29 in the same affidavit.
Page 29.
Of the same affidavit, additional affidavit.
No, the
28, my lord, order operative portion. 29 is irrelevant. Order dated 13 January 2015. Page 36 of the petition, my lord. Fifth one, my lord. There is a clear direction. Lord, only the other petitioners, now those who are claiming to be hereditary trustees, they were consciously, my lord, the court has permitted them to work out their remedy elsewhere. My lord, there is nothing prevents from the authority to hand over the charge. In fact, my lord, this order, direction number 5 in the operative portion, it is clear. Respondents are directed to hand over the administration.
37 is the proceedings that are still
Ramana.
pending.
Administration to the complainant. Administration includes everything, my lord. There is no restriction in the order. They have not sought for any clarification. Writ appeal dismissed, attained finality.
All the keys, Your Lordship. Hundi keys. Hundi of the Amma temple.
If at all they, my lord, succeed in their claim, they will join me. That's all. That there ends the matter. They cannot, my lord, withhold.
Till
this
then, my lord, we have handed over the possession, all the books, registers, everything except the key of the hundi and the ornaments which are valuable, which are kept in the safe custody treasury of this under the Tahsildar, Your Lordship. And also a direction to the complainant herein that whenever there is a requirement in the temple on a festivities or festival days, whenever it is required on important occasions, they can draw it, celebrate, then deposit it until the other claim of the other trustee is disposed of, which is pending. They already initiated that proceedings also, Your Lordship, and that is at page 37.
Except liberty, no relief has been granted to the other petitioner.
In para 7 of the
And your lordship's direction also
order, Your Lordship.
speaks about the accounts. Account should be
Account-
handed over to the.
Account books have been handed over, Your Lordship.
No, they have not done that. Para 7 is silent about it. The direction was clear. It should be a meaningful handover of the charge.
Page 33, Your Lordship, by virtue of the letter at 14/6/2024. There is a list of things that have been handed over. Thank you.
So in paragraph 7, they say that these ornaments are required for
That they are free to draw whenever it is required, Your Lordship.
jewelry belongs to deity and the same
Yes,
is
sir.
required on special occasions, festivals,
Yes, sir.
to decorate the deity. So you make available.
Yes, sir.
My lord,
Whenever it is required, they can draw it from the Tahsildar. Ornaments, we have made it very clear in our, they have to hand over everything. It's only the key, it's not the ornaments. Like,
This percentage. Either we are helpless or you are helpless. You have to choose who are helpless.
Yes. Well, if you have to, Your Lordship, the only thing is, because the liberty is granted.
Helpless in obeying the order. And we are helpless in passing the order.
I will,
So decide what you invite.
I will seek instructions and submit.
Not instruction. It is so many times it is adjourned, adjudicated, clarified, told, advised. Now we are warned. So many things have happened. So now only thing remains is compliance. When you will comply?
A week's time.
Next Wednesday, not beyond. Full stop. The delaying of the compliance of the direction of learner single, which requires handing over of the administrative temple in meaningful way, not just by handing over keys, but also record another article.
Records have been handed over, Your Lordship. Records have been handed over.
No, it is to be
Except
deprecated.
letter, nothing is given.
Is to be deprecated. Full stop. Last chance is given to learned additional government advocate, Mr. Chaffer, to ensure that the respondent complies with the direction in letter and spirit, telling which the court will have to be thorough in dealing with the contemner. Send over to
Grateful.
25th of September, on which date the compliance shall be reported.
Like.
Number 22.
Serial number 22, I appear for the complaint minutes.
That's.
The order of the single judge has not been fully complied, my lords.
Pardon?
The order of the learned single judge has not been fully complied, my lords. On the last date of hearing, they have filed a compliance report, my lords, but the order is not fully complied. My lords may see
Directed to accomplish the
order.
implementation of subject Carrera orders and listed.
Please, my lords.
Lords, on the last date of hearing,
My lords may see order dated 1/7/2024.
we have issued a notification, advertised and called for auction, my lords. Paper advertisement was given. And then the auction was fixed on 10/9/2024, my lords. Unfortunately, no bidders came forward, my lords. My lords may see all 6 apartments were put for auction, my lords. Now, next date of auction, again, we are advertising and conducting on 5/11/2024, my lords.
So what is?
Lords, this we had advertised on 9/20/24. Once again, my lords, and called for auction.
So it is under process of compliance.
My lords, but no bidders came forward, my lords, to auction the property, bid the property, my lords. Again, next date of hearing, next date of auction is fixed on 5/11/24. We will once again have to advertise and auction the properties, my lords, all 6 attached properties, my lords.
Make a submission, my lords.
While allowing the writ petition by order dated 5th July 2023, alone a single judge, inter alia, directed respondent number 1, the Deputy Commissioner, Bangalore Rural District, and Tehsildar, Bangalore, and respond to this Tehsildar, Bangalore, to accomplish the implementation of the subject matter K. RERA award orders, which are mentioned in paragraph 8 of the writ petition. Report compliance to the registrar general of this court within 3 months. Full stop. When the contempt application in relation to the above direction came up for consideration today from a learned additional government advocate Ms. Pramodini Kishan produced copy of, what is this?
Lords, this is a notification for public auction.
Public notice dated 2/9/24, whereby the auction
Please.
was advertised by the authorities. It was our stated that despite auction date having been fixed, no bidder came forward. It was further stated that the press auction would be conducted as scheduled to take place on 5/11/24. Full stop. The above circumstances, it could hardly be said that there is any willful non-compliance with the directions of law and assembly. However, since the auction is scheduled on 5/11/24, the present proceedings are directed to be listed on 7th.
Please.
On 7th.
Grateful, my lords.
7th November.
Please.
Grateful, my lords.
We'll dispose it on that day.
Please, my lords, please.
Only today it is already disposed.
Correct.
Yes. Shall we dispose of today itself?
No, my lords, let them conduct on 5/7, 5/11. If the contempt
What they
petition is
can do if
disposed,
the
then they will
auction is
not take any steps, my lords.
Rectified. Anyway. See these items on proceedings. You're auctioning which property?
Lords, all the 6 apartments which have been attached, my lords. It's mentioned in the notification.
This paragraph 8 of the petition lists many projects. So all your auction.
No, my lords, only which are attached, my lords. Only those which have been attached.
They have not attached all the
If-
flats, my
if
lords. Only 6 flats have been
nobody
attached.
None come forward, then you'll be switching over to other properties.
Lords, in the vicinity, which all the properties which we could identify and attach, those properties we are auctioning, my lords.
In the event, the second proposed auction does not fetch any bidders, learned additional government advocate shall take instructions as to what steps the authorities intend to take to switch over for auctioning the property other than present one. Is it right or not?
Originally, Lord's jurisdiction issue would come, my lords, here East
You're
Tahsildar
not directing, you're just observing.
obliged.
Grateful minutes.
Number 23, Manjunath, yes.
Yes, last time it was heard.
Lord had asked if there was any documents regarding my application in the year 2000. Like.
Your army man.
Service.
Lords, your lordship had directed me to produce all the application.
She is saying that he prior in point of time.
2000, my
Yeah.
lords, they have made an application with respect to some other land which was already rejected according to their own submissions. Now, this application and this writ petition, my lords, pertains to this Chikmagalur Taluk and Channagondana Halli. With respect to that, my lords, they have made only in the year
So
2021.
that taluka is a separate category.
Please, my
And
lords.
there is application is subsequent in point of.
Please, my
There
lords.
are many people.
101 applications. I
stated.
have produced all the applications, my lords.
Of 4/9/2024, they are compliance affidavit.
Hmm.
In R4, R5.
R5 of their reply. Their reply.
Their reply.
Their reply.
One of their contention in their affidavit was that I have not filed Mangalore Tahsildar, and the same is made before Mudigere Tahsildar. But I have made my application in the year 2000 before the Chikmagalur deeds. And I have also,
Page 97. Or
yes,
not?
ma'am.
23rd May 2000.
This is my 2000 application, which I have made to the PC Chikmagalur, for which, my lord, I have in my,
You are Sudhir R.
yes, ma'am.
Yes.
This is with respect to Javali. Village may kindly be seen and Taluk may kindly be seen.
My lord, they have given I had filed an RT application in the year 2009, inquiring about this application, which I have filed in my rejoinder.
We only want.
No, my lord, I would like to tell that, they have replied.
No,
saying-
you are this order of learned single judge.
Is with respect to Channagondana Halli methods, with respect to the 20 application they made in the year
And
20.
survey number 218
Please, madams.
at Channa Godanahalli village,
Please.
Vasthare Hobli, Chikmagalur Taluk. So only we want that your application for this land in this taluka, which is in first point of time. Where is that?
My lord, kindly see their compliance update dated 7/6/2024. The observation made by the accused is that I submit that granting 177 ex-servicemen or servicemen applications, 846 acres, 18 quintals of land or 2 hectares can be granted is required. My lord, my application is only pertaining to survey number 218. I have also filed an RTI application, my lord, can kindly see next year, G, my lord. In
You are showing page 197 is for.
dated 1990. Dated rejoinder.
Madam, we only want to know.
I would like to just
Yes.
point that I have made an application only pertaining to survey number 200. But
That is-
their reply is that they do not have an extent of 800 and so hectares of land to be allotted. The accused is taking the personal opinion that I'm filing a group application and it has to, like, there's the extent of land. which
So
I
the
have.
application is of in respect of survey number 218 that is admitted.
My lords, yes, please, my lords. That is made in 21, my lords. When they made, there are 100 and his serial number is 101, my lords. I have produced all the applications before this honorable court. Right.
The writ petition
2000
number 26700 of 13, dated 25/8/2014, whereas
We will not be able to go in this debate because that is not relevant. We want the date of your application, which is first in point of time in relation to survey number 218. And if the council, government council is able to show any other application prior to your application, we'll close the country. And if any application is not shown, which is prior in point of time to your application, we'll call them to put the country.
Lordship, may kindly see Annexure R1, my lords, where I have produced all the applications.
So instead of wasting the time today, you find out your application first in point of time in respect of this survey number and the date thereof.
I'd just like to tell that, highlight that in the list of applicants, what they have filed, none of the applicants have asked for this particular survey number.
So show that.
Only my application is there, Lord. And in their list, I have all the,
So none of the applicants have asked for this land.
no, my survey number 218, nobody has asked for it.
It's not like that, my lords. Certain amount of land will be reserved, my lords. And we have to go by priority according to the availability of land. Whether that land is free or not, that is immaterial. The seniority will have to be followed, my lords, and land has to be allotted. When there are so many applications pending, my lords, out of term merely because the land is available, we cannot grant it to the ex-servicemen, my lords. There are other servicemen whose priority list is there from 2016 onwards.
Okay. Which is your first application in point of time? Forget the survey number. First application in point of time. First in point of time. 2000. This is before 2000.
They made an application in 2000, my lords. It was with respect to a particular land which was coming in the area of forest area. And at that point of time, my lords, I've stated in the affidavit that they owned 9 acres of land. At that point of time, they were ineligible to make an application, my lords. And it was with respect to Moodigere Taluk and some other village, Javali village, my lords, not in respect of this application.
Now you are becoming slippery in your submission. Now you answer that which are the applications which are senior in point of time, that is prior to 2000. Is there any application? If not, then you are supposed to consider the application of this petitioner in order of time.
My lord, I would also like to make a mention that in the documents which they have produced, there is a document of mutation register extract wherein I have sold this property. The property which they are saying that I own, it is not with me anymore. I have sold this property.
Sold.
My lords, any
Sold.
person.
Yes, my lord.
My lords, at that point of time, they owned land. They became an ineligible applicant at that point of time. Therefore, their application cannot be considered. In 2000, my lords, when the ex-serviceman made an application, at that point of time, he was owning 9 acres of land. And that application is disposed of.
My lord, that application is.
Are you insisting on this 218 only?
My lord, I had filed an application, my lord.
No.
And this land is free from all encumbrances, my lord. They have made a spot measure and they have issued a notice that this land.
Do you insist for survey number 218 only?
Yes, my lord. like to kindly,
Please.
one last point, my lord, I would like to kindly draw your attention to this writ petition.
If that is the case, my lords, then everybody will start claiming, my lords, we will not be following the seniority list. Merely because the land is available. Overlooking the seniority, we cannot allow
You
the land.
appear to be not correct on two counts. Number one, there is no application you are able to point out which is prior in point of time to 2000, which is the first application of the petitioner. Secondly, there is no application of any other party in relation to survey number 218. So in both ways, she becomes entitled to get the
Lords,
land.
may I make one submission? 2000 application, my lords. At that point of time, the complainant was ineligible. He was holding 10 acres. Our land grant rules, my lords, prohibit such a grant of land, my lords.
My lord, on that explanation, my lord.
I've produced the RTCs, my lords, where he was holding 9 acres of land. He doesn't become an eligible grantee at all at that point of time, my lords. 2000, and it is in respect of some other village and some other taluka where it doesn't fall under the jurisdiction of this Tahsildar, my lords. Lordship may kindly see the order. It is with respect to Channagondana Halli, survey number 218. Not at all with respect to 2000 application, my lords. And there cannot be a contempt with respect to 2000 application at all, my lords.
Where is your last affidavit?
My lords, it is dated 4/9/2024.
4/9.
Please. Your Lordship had directed to produce the entire list of applications which we have produced, my lords. And the applicant's application is at page
So the parties are here, the matrimony. They are here.
70, my lords.
Very good. That is a fact. It's here. Two applications. You have produced so many things in the rejoinder.
Yes, my lord, I would like to kindly draw your attention to this one judgment of WP 26700. In that, the honorable court has issued 14 directions, my lord. But when considering the applications of ex-servicemen, in page number 77 of my rejoinder.
Which is that 14 direction, 13 that in this 26700.
Page number 77.
77.
79. 79, page number 79. Paragraph number 8, direction number 8. No application shall be rejected without certain or assigning any valid reason. Non-availability of land in any particular village applied for shall not be a reason for rejecting the application. In case, direction number 9, In case applicant seeks land in any particular survey number or particular village, the same shall be considered for allotment in the event of such land not being.
So that is what we were asking. Are you ready for this alternative?
Well, I have asked for a specified land for which I have.
That is available.
That is available, that is specifically kept for servicemen. Which I've also.
That is kept for ex-service.
Yes, my lord. May kindly see annexed G and H.
Page.
Then it
80,
will be
80,
seniority.
84. This is my application. 84 is my application. Regarding inquiring for survey number 818, my lord. In 88, page number 88, it is their reply. It is the reply from the RTI for my application.
Yes. Then there is no case. Page after 88,
My lords, may I make one submission? my
after
lord?
page 88, you don't have any case.
Lords, we, 2013
by
is
the
the
Tehsildar.
judgment produced by,
This page 88 read with the direction number 9 of the order, which
lords, thereafter, the state government has issued circulars, my lords, because of the deficiency of availability of land.
we are not bound by the circulars. You are bound by the directions of learners. And what do you propose now?
Lords,
But
foregoing, my lords, foregoing 100 ex-servicemen, my lords, my learned friend cannot insist on granting where she is at 101, my lords. The very circular says that seniority has to be followed. Merely because the land is available without following the seniority list, land cannot
Circulars
be.
can't work against the directions of the court, which is in 26700, more particularly paragraphs 8 and 9, in 9 in particular, at page 80, read with your own order at page 88 of Tehsildar, which says that this land is kept for ex-servicemen only, and there is no other claimant for that land.
Lords, there are 100 ex-servicemen in waiting in the list, my lords.
So you both have done a lot of homework, but let us see whose homework succeeds. So what do you propose now? Same response from us. Either we are helpless or you are helpless.
I'll take instructions, my lords.
Take instructions on Thursday at 2:30.
Right.
To be listed at, otherwise we'll pass the order. Yes, and you bring out your circular, madam, on that day.
Please.
Separately give us, we'll appreciate, we'll consider.
Obliged.
My brother is rightly saying that we will not compel you to breach the seniority, still we will grant the relief. Because the complainant says senior to all other applicants, at least in respect of this land.
I'll take
See on that
instructions.
day.
Well, Lord, I'd like to make a mention that in all my latest applications, although in my subject reference, I have also made a mention that I have been applying from the year 2000. So it is well aware in their knowledge that this.
It's not rejected. Come on Thursday. So there is a matrimonial contempt matter, yes. To be taken in chamber. We'll assemble at between 2:45 and 3.
Court officer, Court officer. Serial number 66 was mentioned in the morning, my lord. The matter was specifically listed at 2:30. Serial number 66, my lord. Date is given for next month, anytime next week, my lord.
What is the matter?
My lord, tender matter, my lord. Mandamus to release payments of 10 crores, 81 lakhs.
My lord, the matter I mentioned this morning with regard to recovery.
My lord, next week.
Learned government
I
advocate
filed
wanted
an
time.
application for urgency, my lord, since we had.
She wanted time, therefore we said that afterward.
My lord.
She wanted next week to be.
Any date
to her
next week,
fairness,
my
but
lord.
we said it afterwards. What is that urgency?
My lord, surface proceedings are pending, my lord. IBC proceedings are initiated. We are bankrupt, my lord.
What is the connection with that?
My lord, the loans was raised in relation to this scope of work, my lord. Kindly, my lord. Any date next week, my lord. At 2:30. Matter was heard in part, my lord.
We'll be able to take instructions next week.
My lord, I'll try, my lord. I'll try. I'll make an attempt. Your lordship may have it next week.
Next Thursday.
2:30, my lord. Kindly.
That will.
Please.
Obliged, my lord.
Scheduled for today. Scheduled for today.
Today is scheduled for today.
Yesterday.
All today is scheduled for today.
Yesterday is.
We'll see, take up. All matters we trying to take up. But we have to hear you, Mr. Party in person. You and advocates. So. नहीं.
Says list 1, cell number 7.
This contempt petition 7/22 of 23. In this contempt proceedings, 8 years daughter, Kumari Nina, and her future are in focus. The complainant father and respondent mother appear to be strewn apart because of their apparent matrimonial disputes, some of which surfaced and some of which did not. In course of the proceedings and the interaction. Paragraph. The Metropolitan Magistrates Court at Mayo Hall, Bengaluru, by order dated 10/3/23, gave liberty to the complainant father to visit his daughter Kumari Nina, India, Indy, pursuant to the contempt proceedings filed by the husband, his father. This court had an occasion to pass order dated 12/8/24, whereunder it was provided that the parties may meet at a public place, which was Gopalan Mall, Bengaluru, where the daughter would meet the father and vice versa. It was provided that if the daughter desires to talk to the father without anybody's presence, she shall be accordingly permitted. To be with the father as much time as she can be. The proceedings next came up for consideration on 12/9/24. The meeting between the father and the daughter had taken place by the time, as per the earlier order dated 12/8/24. In course of the hearing, it was given out, it was expressed before the court that daughter was bit hesitant to be with father when the meeting was arranged as above. Since it was human matrimonial view, EMBRI, GLIO, and the welfare of the child was paramount for the court. The court decided to interact with the parties in an endeavor to search out the simmering issues between the parties and the rival claims. Paragraph. Today, the complainant, the parties were called in the chamber. The court interacted with the father without anybody else's presence. The court then interacted with the mother, the child, Nina, and their learned advocate. Paragraph. After assessing the views of the mother and father, the court thought it fit to interact with 8 years old Nina, Kumari Nina. She is a all smiling girl. The interaction with her was done in presence of 2 lady court officers to make the child feel comfortable and natural in the interaction with the court. While as a court of law, while as a court of law, the concern is to the implementation of the order or otherwise. Since the delicate issue of human relationship and the matrimonial ties and the future of child was involved, so we put related questions to the parties. The court came to know that husband and wife hail from different religion. They have lived their matrimonial life happily for long 7 years, but for the subsequent developments. As stated above paragraph, the sole and paramount consideration even while dealing with the contempt proceedings for the court is the welfare and development of 8 years old girl child. Full stop. For any child and for his or her well-being and emotional development in the life. Love of parents is indispensable. Neither the affection of father could be spared, nor the love of mother could be kept at a bay, BAY. With above small preface, the court deems it fit to continue the arrangement provided in order dated 12/8/24 for further for further 6 weeks. The following directions are reiterated, extracting from order dated 12/8/24. So quote paragraph 3 and 4. While the parties will meet as above. Preferably every Saturday or Sunday, when you will meet? Madam,
There is a examinations which will be conducting from 23rd, child's examination.
Saturday, Sunday will not be examined.
No, my lord, Saturday is there.
Sunday,
23rd Saturday. is there.
Sunday. Sunday,
Saturday is fine.
Sunday is all. This Sunday is examination. This Sunday there is no. All right. Every Sunday. At 11 AM. It was considered necessary that instead of Gopalan Mall, as was provided earlier, the meeting may take place Onyx Mall, Whitefield, Bengaluru. Full stop. The child in Kumari Nina shall be permitted to be with father. Full stop. The mother shall also join the company. In order dated 12/8/24, it was inter alia recorded upon the submission of the parties themselves that the complainant and respondent will have lunch together on the day when they meet. The court expects that the said cordiality will continue during their future meetings. Paragraph. At this stage, it was submitted on behalf of the respondent number 1 mother that examinations are going on. And the daughter Nina would be busy. Full stop. If it is provided in this regard that if the daughter is, if the child is to take examination on any Sunday, such Sunday may be spared. And the parties may not meet on that Sunday, except above qualification, it is observed and directed that the parties shall meet as above every Sunday, and the father shall have the visitation right
Submission, my lord. On every Sunday, it is quite impossible.
to be, father shall have.
Child is feeling very much uncomfortable too.
We are not tolerating any interruption when the court is passing order. And I need not repeat that in every matter. Correct? What did you write? It really breaks the chain. This is the worst area you make us angry, at least me, interrupting in course of the order. Yes. Except on the examination day. Full stop. The proceedings shall be listed next on 21st, 22nd of October.
Till number 3, Mr. Nataraju T. Till number 3.
Learned advocate was present in both the calls, in the first session as well as in the second half. In the larger interest of justice, instead of dismissing the petition for want of prosecution, stand over to next Wednesday, that is 25th.
So, list number 2, seal number 3, Ajay Kumar Patil.
What happened?
PG may not have already held, but this can be allowed. Central government, in fact, is allowing.
That madam was to, yes.
Can be allowed. In fact, the honorable.
You have to take instance.
Pallavi case, they once followed Anushka and allowed in PG also.
Pallavi.
Yes. That will copy. Thank you. It is only the state government which is
There are
denying.
18 million.
Central government is allowing them.
In this case, in this Pallavi's case, it was PG, medical, there are 18 million would be allowed. In this case, although the OCA card relied upon by the petition on 4/8/2022. Fact that he was in fact issued the OCA registration card first on 2/11/2000. That's a document. Petitioners eligibility to claim the benefit of OCA card in terms of the ruling in Anushka is undeniable. The rejection of a candidate at this stage on so and so is not supportable in law. He is consequently directed to be considered in the training counseling rounds by AIMS for all participating for PG medical.
So what is the prayer?
Prayer is to direct respondents 1 to 3, that is the state government and KEA, to permit me to participate, page 17, my lord, permit me to participate in the PG counseling, which is scheduled to be conducted by KEA, page 17.
Today, counseling is going on?
No, central government is going on, but state government is likely to start anytime.
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 Not before Monday.
My lord?
Not before Monday.
No.
So you'll get the order on Monday.
Please.
You will get the order allowed
Please.
in light of this Pallavi. To give the appearance so that, yes,
The jute matter.
I will take up all that. 90 will take up.
Right.
So it is disposed of in today's date, but you will get order on Monday.
Please.
Give your appearance all of. Take, yes.
List number 1, seal number 63.
For the petition.
For withdrawal of petition.
Since we have filed the memo to withdraw the petition, has not pressed minutes. Not,
Pardon?
we have filed the memo for withdrawal of the petition,
Withdraw.
has not pressed minutes.
Which is the serial number?
63 minutes.
63. CCC, that is contempt petition 666 of 2023.
Please, ma'am.
Learned advocate Ms. Samant has
Yes.
points out that memo of withdrawal dated 10/9/24 is already filed. Also the same figures on record. In view of the memo of withdrawal, as the proceedings are not pressed, the petition is dismissed as withdrawn.
Grateful.
Seal number 64, to Nagaraju SJ.
For petitioners, madam. This matter I have filed seeking leave of the Shambhu Court to withdraw this petition, my lord.
Memo is filed,
Yes, memo is filed, madam.
which is where is the memo?
64.
So same order. What was the PIL for?
Lordship, kindly see in this matter, my lord, the challenging the wet well, my lord, underground drainage is proposed to be established in the city limits, my lord. That's why the public interest litigation was filed, my lord. Now all the clearance have been procured by the local bodies, my lord, and also there is assurance by the local body that they will take every safety measures, my lord. And already they have purchased the land as well as they have commenced the project also, my lord.
What is
And the
what is UGD?
Underground drainage, my lord.
Underground
Drainage
drainage.
into 1 acre 20 guntas. And on behalf of residents, my lord, of that locality, this PIL is filed, my lord. But first petitioner is also not well, he is seriously ill, my lord. And for that additional reason also, he doesn't want to prosecute this petition.
Figures on record is the memo dated 12/9/24 filed by learned derogatory petitioner, wherein the petitioner seek permission to withdraw the present public interest petition. Full stop. Dismissed as withdrawn.
Much up. It's number 65. Mr. Lam Chidanand.
Here for the petition, Lordships, next Thursday it may be called, your Lordships, next Thursday it may be called, your Lordships, the client is out of country. That is the reason. I'll make submission on that day. I'll not take any adjournment, your Lordships, because I've instructed what this honorable court has told, your Lordships. That's it. Next Thursday at finally, no more adjournment will be taken.
Next.
66 adjourned, seal number 67. The Sampath Anand Shetty.
Public interest litigation, wherein residents of the Pukandaru village have been deprived of the playground area. Now, so far as fifth respondent is concerned, as per election D, my lord, when we turn to page 72, there is a conditional sale deed in favor of the fifth respondent, as back as on 5/4/2007. So directly, conditional sale deed can be executed, and it is the same is in utter contravention of regulation 3 of the Karnataka Housing Board Allotment Regulation. Wherein there should have been a publication and due notice, and nothing of that has been followed. And the condition in the said civic amenity site bill, that at page 74, at condition number 1. 74. The second party shall construct building suitable for school as the case may be duly providing all infrastructures as relevant to provide facilities to accommodate that objective within a period of.
So only in respondent number 5 and 6 have filed their objection.
Yes,
or any other respondent has filed.
5 and 6.
5 and 6.
5 and 6, man.
I
No,
represent only the Grama Panchayat notes. I represent the Grama
You are for
Panchayat.
Gram Panchayat.
Yes.
So there,
Board has not filed objection.
after the
Which.
as per the conditions, the land was not utilized till 2016.
Which condition? Which condition?
Condition number page 74.
Page 74.
Second party. Should have been utilized, even it is for the.
Condition number 4. The site which has been. Condition number
Page 74, condition number 1.
1.
Yes. Second party shall construct a building suitable for school as may be, duly providing for all infrastructure as a relevant, provide facilities to accomplish the said objective within a period of 2 years or within such period the time allowed by the second party in conformity with the rules of the law in force from time to time. No, it was, in fact, first of all, it is in total violation of that regulation of the.
So what they are doing what now?
Now, after that.
School, my lord. A school is constructed. School, yes, primary school.
Now, 15/9/2016, this land was not utilized.
Now it is school is constructed.
Yes, my lord. It is allotted for a school and the petitioners, my lord, the petitioners are the neighbors, two persons who have encroached a portion of the.
This condition provides for construction of school.
Yes, my lord. Yes,
No, no,
and it is done.
After this, my lord, that within a period of 2 years, they have not constructed anything. On 15/9/2016, this land was not utilized and there was a notice issued by the Karnataka Housing Board as per Annexure E at page 80.
Page 80.
80.
No, what they have done now?
Now, after that, my lord, page, I request your lordship to turn to page 70. Now, under the guise of the civic community site, they have encroached upon the playground, which is meant for us. And this was clubbed, civic community site and the playground were consolidated. And they sought for license and they are constructing now, which I can demonstrate at page 70 map. On the middle, my lord, if your lordship sees school and CA number 1, CA site, CA 1. Now, next to that, to the east of that, there is a playground, which the petitioners are interested.
This land was
Yes, civic community site.
general. It was specified civic community.
It's a civic community site allotted to the school in a village called Kukundur.
Page 76 also, the boundaries is very clear, apart from the sketch which I am pointing out. Now, what they have done is, the entire playground area has been encroached upon by them and license is obtained and the school is constructed. Now, ultimately, the petition.
It is used by school.
It is by the school. Kindly see the.
That area of playground is used by school.
Yes, yes.
They were allotted
Yes,
with civic community site 1, my lord, page 76. Your lordship, kindly see the boundaries, civic community. They were granted. 76. Schedule of the CS site. Civic community site CA1 formed in survey number 282 of 6 of by Karnataka Housing Board, bounded east by park, west by MIG 1 and 12, north by park again, and CA2, which your lordship could see at this juncture at page 70, the boundaries. The school is first, my lord, CA1, playground and community center, CA2. This is what, now what they have done, measuring totally 880 square feet. After, in 2016, they were given notice that you are not utilized for the purpose of that, Lord. They encroach upon the entire playground area and obtain a license, which is clear, which I am able to demonstrate from the our concern is about that, but under the guise of the civic community site allotted, they have encroached upon the abutting area and they have deprived us as the entire playground area. That to that extent we are concerned, you know. I will point out from that, my lord.
Ground should like Jata.
Kindly turn
Ground
to
should only.
Annexure M, my lord, page 116. With reference to that original plan, Annexure C. Now kindly turn to Annexure M at page 116.
Ground should like Jata.
The lordship got Annexure M, page 116. This is very clear. The civic community site and the CA1, they have encroached upon the playground and they sought for permission and now they have went to school. So in the process, the playground area meant for the residents have been deprived. First of all, they have not, the very allotment is in contravention of the regulation. Then they are not utilized. They went on issuing notice. After that, the fifth respondent obtains a license. 116 page. Kindly see the civic community site with playground. This is the area they have encroached upon, and the 5/4/2007 conditional gift, conditional sale deed is only in respect of civic community site. The present petitioners are concerned with the grant of license in which the built a construction, they have put up a construction in the playground areas. This is very clear. That's why, my lord, if your lordship sees this annexure C in juxtaposition with the annexure M, which they do not dispute and there is no factually. Now, this is how they have proceeded. And ultimately, the petitioners are deprived of the playground area, for which we have given a representation as per annexure.
Petition, who are petitioner?
Pardon me?
You are deprived of playground.
Yes, playground meant for the residents.
Ah.
They are before this honorable court. Now, first of all, the civic community site allotted to fifth respondent is in violation.
Hudko colony Hitrakshak Samaj.
Yes. These are the residents who have come before this honorable court.
So you are deprived of playground.
Yes. That is why we have given representation
Yes.
that has been not considered. They are,
Colony members. Colony members are deprived of playground,
yes.
which is used by the school.
No, they I mean, they are not allotted with this playground area. They were allotted with civic community site, which have,
Now ground is used by the school,
the entire construction is
Entire.
also done in the process.
by the school.
We are deprived of.
The area, open area or place or land, which is subject matter of dispute, is presently used by a school
Yes.
as part of playground.
No, not playground. They have built a they have
Build
built
a
a construction.
Construction.
The school building itself. We are deprived of the playground.
So this playground is converted into civic community.
No, it's not converted. The AHB has not converted.
What is your say? What is your case?
I appear for respondent number 5 and 6.
Who are 5 and 6? School.
5 and 6
School.
School. They made an application for allotment of this site called a particular site in a village. After consideration of their application, allotment was made. Well, this school had no money for construction to take up construction, and it got delayed. They gave representation, and the housing board allowed their application and permitted to construct. They took the license from the Gram Panchayat and constructed the school. Kindly come to annexure R10. The school building was complete. Everything is now ready to be occupied in the year 2022. These person, the petition is instigated by 2 persons, I have stated so, who have encroached portion 2 cents of land which is granted to the school. And they instigated these persons to file this present petition.
You have filed, Mr. Panchayat, you have filed reply?
But I have. No, Panchayat, my lord, the Panchayat has to give door number to the school.
Who has given you the permission?
No, Panchayat has.
So Panchayat has filed reply?
Not yet to file not.
File it then.
Please.
Respond number so and so shall file. Respond number 3, Ukandur Gram Panchayat shall file reply to the present petition.
They have to.
Before the.
One submission. The Panchayat has issued the license. We have constructed the building as per the Panchayat license. Now, a door number need to be assigned because the school is not. The whole purpose of this petition is to stall the school. The
They have to issue door number.
Panchayat, responsible panchayat shall file reply to the present petition responding to the case of the petitioners.
How they could include the playground area, that's also they have to apply.
There is
No,
no.
they cannot grant license.
There is
10
no
or to
order of
20
stay.
23rd October.
There is no order of stay. But against the panchayat not to give door number. But I have filed an application. The school has filed an application that let the panchayat issue door number. Because the school for the.
We'll take up on that
Yes,
20.
yes. Kind permission. List number 3, seal number 25, Mr. Ajay Prabhu M.
Lord, I have called in question the interim order passed by the learned single judge. Lord, staying the operation of one of our notifications, which is issued under the Jute Packaging Materials Act. Yes. In fact, Lord, the factual matrix is in a very narrow compass. The issue is about the act and the interpretation. Now, Lord, would your lordship have a look at the act, Lord, very short act. In the main one. The same one, the challenge to our notification, which mandates usage of jute bags for 20% of the total production. My Lord, it's a very short act. In India.
You have copies?
In India. Copy could you?
We have filed in.
Lord, it's a very short act enacted in 1987. Lord, the object of the act was to protect the jute industry. Lord, the validity of this act was challenged and upheld by the Honorable Supreme Court. I have produced a copy of the judgment in the Dalmia case in which the challenge to the validity of the Jute Packaging Material Act was turned down. Lord, the act is at page number 2, short act, my Lord, with just 17 sections. Please have a look at the preamble to the act. An act to provide for the compulsory use of jute packaging material in the supply and distribution of certain commodities in the interest of production of raw jute and jute packaging material and of persons engaged in the production thereof and for matters connected therewith. And then, Lord, we could straight away go down to section 3, which is the operative part. Power to specify commodities which are required to be packed in jute packaging material, notwithstanding anything contained in any other law for the time being in force, the central government may, if it is satisfied, after considering the recommendation made to it by the Standing Advisory Committee, that it is necessary so to do in the interest of production of raw jute and jute packing material and of persons engaged in the production thereof, by order published in the official gazette, direct from time to time that such commodity or class of commodities or such percentages thereof as may be specified in the order shall, on and from such date as may be specified in the order, be packed for the purpose of its supply or distribution in such jute packaging material as may be specified in the order, provided that until such time as the Standing Advisory Committee is constituted under Section 4, the central government shall, before making any order under this section, consider the matters specified in subsection 2 of Section 4, and any order so made shall cease to operate at the expiration of 3 months from the date on which the Standing Advisory Committee makes its recommendation. My lord, I'll take your lordships next to Section 4, my lord, and stop reading. Section 4, Constitution of the Standing Advisory Committee. The central government shall, with a view to determining the commodity or class of commodities thereof in respect of which jute packaging materials shall be used in their packing, constitute a Standing Advisory Committee consisting of such persons as have, in the opinion of that government, the necessary expertise to give advice in the matter. The Standing Advisory Committee shall, after considering the following matters, indicates its recommendation to the central government, namely, A, the existing level of usage of jute material, B, the quantity of raw jute available, C, the quantity of jute material available, D, the protection of interest of persons engaged in the jute material and in the production of raw jute, E, the need for continued maintenance of jute industry, F, the quantity of commodities which, in its opinion, is likely to be required for packing in jute material, and G, such other matters as the Standing Advisory Committee may think fit. So therefore, how it works is, the Standing Advisory Committee comprises of all the experts. They are drawn from different departments, the Agriculture Ministry, the Jute Department, and the Ministry of Environment and Forest, Commerce Ministry. All these experts sit together, they constitute the Standing Advisory Committee. The Standing Advisory Committee meets regularly and then makes its recommendation. Based on the recommendation under Section 3, my lord, we being the central government, will issue notifications specifying to what extent and which industry should use it. Initially, my lord, the cement industry, the food grain industry, and the sugar industry were mandated to use 100%. Over a period of time, it was brought down. The food grain industry still is mandated to use 100%. Sugar, my lord, we have shown that because of various reasons, sugar is also exported. So for export, the European countries do not allow this. They insist on HDPE bag. So we have, sir, I will complete, sir. Over a period of time, we have scaled down. So which means we have considered the objections raised by the sugar industry. Since the last 1 decade, we have consistently held it at 20%. Now, my lord, the writ petitioners approached the learned single judge through a writ petition, and they primarily banked on the 30th Advisory Committee recommendations, my lord, which was not the latest. My lord, please have a look at that recommendation, which is at page 115, 115. Lord, this recommendation was made by the Standing Advisory Committee as early as 26th December 2023. During that period, there was a little, I'm sorry, not this, page number 120. Page number 120. 120. This is the minutes of the 30th Standing Advisory Committee, which was held on 21st of July 2022, more than 2 years ago. During that period, there was a slight lull in the production of jute. Lord, for that purpose, may draw your lordship's kind attention to page 122, para number 6, which indicates that the demand is greater than the supply. If I may read para 6 at page 122. Lordship got page 122, my lord. Para 6. Lord, page 120 is the minutes of the meeting to demonstrate that the demand during that period for jute bags was more than the supply. May I draw your lordship's kind attention to para 6 in page 122. Lordship got that? Jute Commissioner submitted that the average sack production is around 9 lakh metric ton. It is anticipated that there will be requirement of 14.3 lakh metric ton of jute bags for packaging of food grains in the jute year 22-23 and the SPS and the FCI. He informed that the likely availability of raw jute in 2023 would be 21 lakh metric ton. He also informed that the provision of 10% procurement of jute bags through government e-marketing as approved in previous cabinet committee CCA notes couldn't be implemented since the demand of jute bags is more than the supply and the maximum price of B12 bags is so and so. So this indicates that there was less. Bearing in mind that there was a depletion in production, please look at the recommendations on the next page, that is page number 123, para 11. After taking into account the deliberations and the facts submitted before the committee, the SSC recommended the following commodity-wise reservation norms under the JPM Act 1987. A, food grains, 100% of the food grains procured by SPS and FCI may be reserved for packing in jute bags. Considering the situation of demand-driven supply of jute bags required for packing of food grains, but we can skip food grains here. We can straight away go to item D on the next page. Sugar may be exempted completely. That was the recommendation. E, exemptions. The following may be kept out of the purview of the reservation under the JPM Act, that is packaging for export of commodities, and then small consumer packs of 10 kgs and below for food grains, bulk packaging of more than 100 kgs. The meeting ended with a note. So in the 30th meeting, the Standing Advisory Committee recommended that the entire sugar may be exempted. But there was one more meeting which was held about a year later. That particular minutes of the meeting I have produced at page number 196. That was held in the previous year, that is 26th of May 2023, page 196. Please have a look at the members of the Standing Advisory Committee at the second half of page 196, which indicates that there are secretaries from Department of Food and Public Distribution, Department of Expenditure, Economic Affairs, Consumer Affairs, Chemicals and Petrochemicals, Agriculture and Farmers Welfare, Environment, Forest and Climate Change, Commerce, and there is also a Textile Ministry representative, as well as the Fiber Textiles, and finally the Jute Commissioner. Lord, in this, Lord, the page 197 is the minutes of the meeting, which was held on 26th of May 2023. The representatives of the Indian Sugar Mill Association, Lord, which is of which an affiliate is the writ petitioner before your Lordship. Item number Roman 1 there, below 3. It says the representatives from Indian Sugar Mill Association, ISMA, and National Federation of Cooperative Sugar submitted the following. So they laid down their recommendations or whatever they had to say before the SAC. And then there were representatives from other states. For instance, if you look at page 198, item number 4, it says representative of Government of Punjab. And then below that, representative of All India Flat Tape Manufacturers Association. And then there are different representatives. Page 200 indicates that at the center, the small paragraph in the center, chairperson stated that jute, geotextiles and technical textiles are emerging segments and jute industry should proactively grab this opportunity. Further, the concerns of AFTMA in respect of present notification on mandatory packaging jute may be taken care of in consultation with so-and-so. And then item number 4 says the meeting with stakeholder association and state agencies was just concluded. Thereafter, the meeting of the SAC started and the members deliberated on the proposals for recommendation of reservation norms for the year 23-24. And then there is a discussion. And finally, the recommendations are at page 201, item number 10. Page 201, item 10. After considering the views expressed by the stakeholders and those expressed by the members, the Standing Advisory Committee noted the following. Nearly 3.7 lakh workers and several lakh farm families are dependent on the jute sector for their livelihood. The jute industry has capacity to procure the required quantity of jute sacking to meet the food grains. Based on the last 5 years trends, as well as the targeted requirement to pack the quantity of food grains to be procured under the food procurement program, the demand for jute bags is likely to be in the range of 11 lakh metric ton for packaging of food grains during the year 23-24. The industry had demonstrated an average sacking production of 11 lakh metric ton, which includes the requirement for other domestic sector. As per projections of the expert committee on jute, 21.42 lakh metric tons of raw jute is likely to be available during the jute year 23-24, which appears to be adequate to meet the demand by jute mills stroke industry. Jute is a biodegradable and eco-friendly fiber. The jute industry requires adequate sustenance till further diversification and increase in share and presence in domestic and international market. And after taking into account the deliberations and the facts submitted before the committee, the SSC recommended the following commodity-wise reservation norms under the JPM Act. A, the food grains and sugar. 100% of the food grains and 20% of the sugar production may be reserved for the packaging in jute bags. The provision of indenting of 10% jute bag through government e-marketing would be kept. Further, in case of shortage or disruption in supply of jute packaging material, or in case of any other contingency or exigency, the Ministry of Textiles may, in consultation with the user ministry is concerned, allow further dilution of packaging material up to a maximum of 30% of the total procurement of jute bags by SPA's FCI in the whole jute year. In case the procurement agencies do not place indent for jute bags to pack food grains as per supply plan prepared by the Department of Food and Public Distribution, and bunching of demands takes place, then the jute mill shall get reasonable additional time for supply of jute bags, provided that if the mills fail to supply the bags in the extended period, the condition relating to dilution shall be applicable. Exemption. The following shall be kept out of the purview of the reservation under the JPM Act, like previous. Packaging for export of commodities, sugar fortified with vitamins, small packs of 10 kgs and below for food grains and 25 kgs and below for sugar, bulk packaging of more than 100 kgs, sugar packed for export but which could not be exported on the basis of an assessment and recommendation by Department of Food and Public Distribution. The meeting ended with note. In pursuance of this 31st SAC, we issued the impugned notification note, which your lordship will find at page 115. Page 115 is the notification which is impugned in the writ petition. If I may read page 115 notification, 26th December 2023, whereas the central government is empowered under subsection 1 of section 3 of so-and-so Act to specify by order the commodities or class of commodities or such percentage thereof to be packed for the purpose of its supply distribution in jute packaging material after considering the recommendations of the Standing Advisory Committee, and whereas the central government has in exercise of powers under so-and-so constituted the Standing Advisory Committee dated so-and-so to recommend the norms. And whereas the central government, after considering the recommendation made to it by the Standing Advisory Committee, is satisfied that it is necessary in the interest of production of raw jute and jute packing material and of persons engaged in the production thereof to specify the commodity or class of commodities and percentage thereof to be packed in jute packaging. And then they say, now therefore in exercise of so-and-so, so-and-so, and then they lay down the table. Exactly as per the recommendation made the Standing Advisory Committee. Food grains 100% and sugar is 20%. The validity was this up to June 23, which, my lord, by the second impugned notification, which your lordship will find at Annexure B, the operative part is at page 118. We have extended it until September 2023. Now, my lord, a couple of formulations that I want to lay before your lordship sees. This particular the impugned notification has been issued pursuant to a policy decision. It is an administrative decision which complies with the policy. Lord, the policy is made by a body of experts, Lord, which I have demonstrated by reading how the constitution of the Standing Advisory Committee is made. The Standing Advisory Committee, after giving an opportunity of being heard to all the stakeholders, recommended for usage of 20% for usage of jute packing material for the sugar industry, and strictly in compliance with the provisions of section 3, Lord, which I read to your lordship. By following the recommendations, we have issued the notification. Lord, the judicial review of an administrative decision is possible only if it is in violation of the policy, or if it is in contravention of the act, or if it is arbitrary, or finally, my lord, if it is malafide. But none of these grounds are urged in the writ petition. There is no allegation of any malafide action. The grounds which are raised in the writ petition are that the notification is in contravention of the act, my lord. I've read out to your lordship that there is a recommendation by the standing advisory committee. I have followed it. I do not foresee how it is in contravention of the act. Then, my lord, the writ petition is mainly focused on certain scientific reasons.
Where is that recommendation again, page?
My lord, the recommendation is at page number 196.
197.
It begins at, my lord, the office memorandum is 196. The minutes begins at page 197. My lord, the operative part of the recommendation, your lordship will find at page 201. I'm sorry, 202. My lord, one significant point, my lord, at the very premise that I would like to lay before lordship is that the writ petitioners suppressed this latest recommendation before the learned single judge.
It's 202.
Yes, this 202 they did not file. They filed only the earlier one, the 30th SSC meeting, which was held in 2022. And on that basis, they argued that, look here, the advisory committee has recommended, given complete exemption. Therefore, the impugn notification is in violation of the SSC recommendation. No, they had access to it. It is not that they did not have access to it. These are all publicly available. I had to produce it before the learned single judge. Learned single judge did not even permit us to file statement of objections. There was absolutely no such haste, my lord, to pass such a sweeping interim order, staying the operation of the notification, my lord. It has got food grains, it has got sugar, pan-India. My lord, we have a mandate of law to protect the jute industry. The sugar industry may have its difficulty, but we have a mandate by law to protect the jute industry and people associated with it, which is why, my lord, there is a special body which is required. So, my lord, my respectful submission.
The petitioners belong to sugar industry.
Yes, they are an association of sugar mills. It is not individuals, it is an association.
Why they don't want to pack the sugar in this jute?
No, their contention, my lord, as stated in the writ petition, is that couple of things. My lord, that jute bags are porous, and then
that is what the learned single judge.
Yes, my lord, I'll meet that argument. I'll meet that argument. My lord, in fact, please have a look at the last 2 pages of my. My lord, the Bureau of Indian Standards has recommended 3 types of bags. My lord, there are 2 issues on which I'm sorry. Judge premised a prima facie case on 2 points. Number one, the contamination, alleged contamination of moisture. And second, the batching oil used for making of the jute bag being carcinogenic. These are the 2 points which he raised. Now, please have a look at page 214 in my writ appeal. Page 214. The Bureau of Indian Standards has recommended 3 types of jute bags for the sugar industry, or for packaging any food commodities. Please have a look at page 214. Page 214, my lord, is the specification for packing. In particular, may I draw your lordship's attention to page 215, where 3 types of bags are recommended: type A, type B, type C. In type C, your lordships will see after the dimensions at the bottom, there is plus 32 liners. Lord, I'm reading page 214, which is the beginning of the Bureau of Indian Standards specification for the jute bag packing. And in particular, my lord, I am attempting to draw your lordship's attention to table 1 at page 215, requirement of bags. In that, under type C, lordship will notice that there is a plus 32 liner. So what it means is, these days, there are jute bags available with a liner. It can protect the sugar or any commodity inside it from moisture. Number 1. Number 2, my lord, there is some oil is used to soften the jute when they make the bag. They use oil. They use a hydrocarbon oil called a batching oil earlier. Now there is a rice bran oil also can be used. The jute bag costs a little more. It was somewhere around 98, 99, it was discovered that the batching oil can be carcinogenic. Immediately thereafter, through the Ministry of Environment and Forest, we issued a notification to confine the usage of batching oil only not to 3%, not more than 3%. So that is legally permissible. The department, the ministry has permitted that. So we have taken care of both. Now, my lord, the question is, can the learned single judge exercising judicial review go into those aspects? Should it not be? The Honorable Supreme Court said it should be left to the experts. I have produced the judgment. Does the single judge have the scientific capability to say this will contaminate because of the moisture? My submission is no. In exercise of judicial review, the court cannot travel beyond the scope of judicial review. The learned single judge should have verified whether my notification is not compliant with the provisions of Section 3, whether I have not followed the recommendations of the Standing Advisory Committee, whether there is any malafide intent in doing this, or whether it is arbitrary. Now, my lord, before the learned single judge, a lot of materials were produced, and it was also contended that one Rangarajan committee had recommended that the jute bag should be done away with. But my lord, as per Section 3, I am required to consider the recommendation only by the Standing Advisory Committee. I am not supposed to look into any other recommendations. So what is the error in my notification? I have considered the recommendations of the SAC. I have followed the mandate of Section 3. That is 120. That is 120. 120 was produced, but 190, 200 was not produced.
Latest respect, not correct. Please have a look at this. I'll leave it here. Let him complete it. I'll show. Read petition.
120. But anyway, the case that was made, I have appeared before the learned single judge. My learned friend who appeared on behalf of the writ petitioners based his arguments on
Page 124.
What does 120 say?
120 says exempt.
Exempt.
At that note, this is July 22. But after that,
Where is that? Please read it.
if I may read page 120.
Paragraph 2. Paragraph 2 of that minutes.
No, my lord. For that, would your lordship turn to page 123? I'm sorry, page 124.
Paragraph 6. No.
No, my lord. Page 124, item D. Shortage of jute is para 6. Somewhere in between, my lord, he says that the demand is more than the supply. If I may read fourth line, he also informed that the provision of 10%
of jute bag is more than the supply.
Yes. So at that time there was this, so therefore they decided to exempt. But
decided to exempt.
Yes, that exemption can be found at page 124.
So up to what period?
For they made a recommendation for that period until
thereafter 202 resolution.
Yes, that was for that jute year.
Reconsider.
It was then the SAC met once again on 26th of May 2023.
That is page 220.
Page 200, page 197, my lord. Page 197 up to 204. 202. 197 to 202.
So the The advisory committee again met.
Yes, they keep meeting. They meet at regular intervals because, my lord, the jute production goes up and down. The food grains production also can go up and down. So it's a continuous process. They meet at regular intervals.
See then 31st meeting next year.
My lord, in the,
Thirtieth of September.
30th September. But my lord, by then the next committee meeting may come. So it is not that after, but the life of the current notification is only till 30th September.
It
But
may be extended.
it may be extended. My lord, ultimately.
That is one more point. You can't extend it without the recommendations. Correct. Okay. Correct.
Lord, there are a couple of authorities, my lord, on the judicial review, which I have filed along with my compilation. My lord, the one that I'm banking on is the second judgment of a three-judge bench of the Honorable Supreme Court in the case of Center for Public Interest Litigation, which, my lord, authoritatively laid down the guidelines on judicial review of an administrative decision. And there, my lord, their lordships have very clearly pointed out that unless the decision is contrary to the policy, or it is arbitrary, or it suffers from mala fide act, and if it requires, and if the decision is made by a body of experts, then they say court should not interfere with those decisions. Lord, therefore, and my respectful submission is that Lord, we have a mandate to protect the juice industry. And the very fact that we have allowed, please see the exemptions. Firstly, 80% of the packing can be made with whatever, 80%. That is not available to food grain industry. And exports, it is not mandatory. Small packaging, not mandatory. Bulk packaging like 100 kg is not mandatory. So their interest is fully protected. After considering their interest, it is kept to 20%. I'm sorry.
Applicable to which class of packaging?
No,
Particular
50 kg.
category?
50 kg, 50 kg bags.
50 kg and 100 kg.
50 and 100. Anything beyond that would be required. And my lord, one of the other grounds raised is 19(1)(g). 19(1)(g) was also raised before the Honorable Supreme Court in the Dalmia case to challenge the validity of the act. And their lordships negated the 19(1)(g) argument. They said, no, that the state government, the government has a duty to protect the jute industry and those associated with the juice industry.
Yes.
Even, my lord, just one final argument is, even today, my lord, every single food grain that we get is packaged in jute bags. I heard my learned friend submit before the learned single judge that this would be carcinogenic, it will affect the people. All of us, whatever we consume today comes in jute bag. And if the sugar industry is so careful in protecting from the environment moisture, they can go for the C-type bags. And if they are also concerned about the batching oil, there are so many jute manufacturers. My learned friend who appears for the mills is also there. There are jute bags which are manufactured using rice bran oil. They will have to spend a couple of rupees more for each bag. And if they have the wherewithal, the cost of the bag should not be a ground to question the validity of our administrative decision. So therefore, not to summarize my submission, the impugned notifications are fully in compliance with Section 3. They are fully in compliance with the SAC recommendations under Section 4. There are no allegations of mala fide act or any arbitrariness. They simply say that they have not considered our recommendation. So therefore, Lord, the single judge committed a grave error in finding a prima facie case, primarily on the basis of contamination, moisture, and bathing oil, which are all based on the properties of the food. He should not have entered that area. He should have confined the examination only to the judicially approved tests. I'm grateful.
Lord, in support of what the appellant is saying, Lord, I'm respondent number 2. I will just add 2 more points, Lord. I just add 2 more points. Firstly, my lord, the notification which is passed under the statute, my lord, has a statutory flavor. And my lord, there's always a presumption of its validity. And my lord, today what has been done is, my lord, by an interim order, my lord, to stay the notification without even hearing us. We have not been heard on the subject. I have not even received notice of it. They have stayed the notification without even hearing us. That's the first point. The second point, my lord, is
kindly see, an interim order is always granted, my lord, to maintain the status quo that existed so that things are not changed. On the other hand, this is a notification, my lord, which has been valid since 2013-14 onwards. My lord, 20% has been the norm. There has been no change in the prescription of 20% from 2013 till date. And my lord, so therefore, my lord, the interim order now introduces a new state of affairs, which clearly is not the object of an interim order at this stage. And the court ought to have at least heard us on all these subjects before the interim order is passed. That's all.
First of all, submission of the learned ASD, my lord, that there was separation of this material, my lord, document, not correct. They deliberately don't produce, my lord, the writ petitions that we have filed. It has, my lord, please turn to, my lord, page 1164 of the compilation that I've given to my lords. This is the writ petition papers. Fairness should be there, my lord, in whatever we do. Which volume is it? 1164.
Volume 3. Volume 3.
Correct. Annexure X.
It's there. With the one here. It's there.
This is, my lord, part of the writ petition papers. My learned friend, learned ASD, my lord, obviously, my lord, too much of papers, so he had no time. Instructions were not properly given. We have produced it. It's not that, my lord, it was not produced. One. Second, please look at the order, my lord. My lords may come back to, my lord, the writ petition, writ appeal itself. Please come to, my lord, the writ appeal papers. Writ appeal papers filed by my learned.
This page is 202 to 197.
197.
Which you are showing.
This is what we showed is 197.
Yes, my lord. Therefore, first submission that there was separation, my lord, with the greatest respect is not correct.
Then,
Then, my lord, please come to, my lord, the 2022 order. Please come to, my lord, page 120. My lords have already noted it. At, my lord, page 222-6, serial number 6 or paragraph 6. 122, so my lord, my apologies, 122. 120, my lord, it starts. At 122, my lords have seen it already. There is a shortage of jute bags. Your lordships have seen?
Yes.
Commission submit the average sacking production is around 9 lakhs. Anticipated there will be 14 lakhs in the jute year, so on, so on, so. Now, my lord, the next recommendation was shown to your lordships at, my lord, running page 197. Please come to, my lord, 200. Same thing continues. There's no figure is identical. Only thing is, my lord, paragraph changes.
200. Yes.
200. It starts at, my lord, 197. My lords have already noted at 200. Para 5. Para 5, my lord. At page 200. There's no change in, my lord, the production of the jute bags. There is a shortage. Say, my lord, 9 lakhs. Please, my lord, compare it with 122, 9 lakhs. There's no improvement. There is a shortage of sugar bag, this jute bags. This is one aspect. More important is, there have been, my lord, recommendations by the Agricultural Ministry saying that, my lord, what has happened is, my lords have seen, my lord, the exemptions granted. For export, my lord, there is an exemption. Why? Because nobody wants to, my lord, have carcinogenic material, my lord, with the sugar. My learned friend said, food grains, my lord, are all using jute bags. We wash the food grains before eating. Nothing, my lord, is eaten just like that. Sugar can't be washed. Moment you wash, my lord, there's no sugar, only watery. Please come to, my lord, page 202. There's an exemption in respect of packaging for export commodities.
This is what, my lord, the learned single judge has noticed all that. And then, my lord, we produced an abundant material. Packaging export commodities, sugar fortified with vitamins, exempted. Small consumer packs, exempted. Sugar pack, my lord, EEB, export but which could not be exported, exempted. Now, my lord, please come to, my lord, what the Punjab government, my lord, holds at page 198 of the same notification. It says, we don't want the food grains now in this because, my lord, it is carcinogenic. This is what has happened. Ultimately, my lord, Indians, my lord, we can be, my lord, cancer-ridden. Exports, foreigners, my lord, should be protected fully. My learned friend very candidly said 3%, my lord, carcinogenic, my lord, this oil is used to be used. That is what, my lord, is carcinogenic. That's what, my lord, the learned single judge has said. And please look at, my lord, the order that was passed. Learned single judge has said, if you want modification, move me again. It's not as if, my lord, what happened was they did not file, my lord, please come to, my lord, the order, impugned order at page 115. Sorry, no, not 115. Impugned order, my lords get that. 24, my lord, sorry, 24. Look at the last line. Paragraph 8. Liberty is reserved with the respondent for seeking vacation, modification of this interim order.
So 2 notifications are stated.
Please, my lord.
The second one is the extension of the validity.
And the extension also, my lord, it requires, my lord, the committee, SSC committee report, it's not there. They must, my lord, sit. It is extension, there's nothing. On the face of it, my lord, it is without, my lord, the Act, my lord, requires mandatory that SSC, my lord, recommendation is needed. SSC did not meet at all.
That's not right.
They, my lord, government unilaterally extends it till 30th of September.
The time is our discretion.
And the shortage, my lord, continue. The carcinogen, my lord, we produce, my lord, abundant material. Export, my lord, they can't have, my lord, cancer. Only Indians, my lord, we must have cancer. I can't wash. In fact, my lord, Punjab government specifically, my lord, in the meeting says, sorry, Lord. Lord, can I continue, my lord, or you want me to come again, my lord? Subject to your lord. No, I understand. There's some. We understand, my lord. We understand.
If you understand, then only 5 minutes. Then we'll continue tomorrow at 11.
My lord, can it be on Monday? Because tomorrow I have, my lord, I'm not here. My learned friend is also not here. That's why, my lord, if your lordship recollects, I initially said tomorrow, Saturday, but then, my lord, 1 day more, my lord. Just 1 day more.
You continue? So that sometime you continue.
Yes, I will,
Yes.
if your lordship permit. My lord, that's what I'm trying to tell your lordships. Liberty was granted. My learned friend, my lord, came, he argued. He was heard. Then, my lord, the learned single judge said, in the light of all this, batching oil, my lord, is carcinogenic. My lord, can I persuade your lord to look at, my lord, my compilation, writ petitions that we have filed? Please come to my lord. First volume, sorry, volumes are different. Page 124, there is, my lord, the Rangarajan committee report, which, my lord, the government had appointed. Regulation of the sugar industry.
But we really are not dealing with finally.
No, my lord. Only on the interim order, my lord. Interim order. My lord, I understand. My lord, fully am conscious of it. That's why, my lord, can I, my lord, request your lordships? When a liberty is granted to them to move the, my lord, very judge, should they not move, my lord, that application? They come before your lordships with some new documents. Is that not in the fairness of things?
Which application? For?
My lord, for modification, that paragraph 8 of the learned single judge's order itself. Liberty is reserved with the respondent to seek page 24. Para 8. In the fitness of things, they should have gone there.
But if I may quickly respond to that. Lord, generally, a learned single judge, when he grants an interim order, ex parte that liberty is reserved. So that I have not heard the other side. Here, my lord, the learned single judge has heard me. He returns a prima facie finding. What will I do by moving an application before him when he has already recorded a prima facie finding?
Not filed.
So which is why I am before your lordship.
Objections not filed. And, my lord, please look at, my lord, recommendation of, my lord, 2022 Recommendation of 2023. Absolutely, my lord, no difference. Shortage of jute bags, my lord, continue. Carcinogenic effect, my lord, continues. Punjab, my lord, government, my lord, in fact, Andhra, please look at, my lord, Andhra says, I don't want sugar packed in jute bags. My lord, please come to page 144. 142, sorry, of the writ appeal itself.
142
my lord.
of this main compiling.
Yes, my lord.
Petition.
No, no, no. In this, 6.2, my lord. Secondary packing. My lords got that.
Yes.
After packing ISS grade, cane sugar in half kg polythene, supplier shall undertake packing in the same, this is, my lord, from Andhra. My lord, please come to, my lords may come to, my lord, running page.
Page.
1 minute. 127, Lord, it starts. This is, my lord, Andhra Pradesh Government Civil Supplies Corporation. Page 127. Act, my lord, 142. They specifically say, my lord, new bags in PP bags, not in jute bags. Jute bags, my lord, nobody wants to take it because two things occur. There is, my lord, the moisture. In fact, cement, my lord, is exempted. I'll point out all that. Cement exempted, fertilizer exempted, exports exempted.
Because of wiping of noise.
Absolutely.
Policy decision.
My lord, moisture, my lord, sir, we all have seen, my lord, the bags. How, my lord, yes, cement is exempted because, my lord, it will solidify. Sugar, my lord, will dissolve. All that, my lord, we place before the learned single judge. Everything. Then he said, all right, if you want to, modification, please file an application. They don't file. Expert, my lord, I point out all that. There are 3 expert committee reports.
But Lana Singhal passed the order without hearing the arguments.
Yes. My lord, what happened was, he heard him orally, my lord. Nothing was placed before him. The material was not placed. Based on our material, my lord, if he wants to place, my lord, these new documents which he claims, can be placed.
Will continue.
Yes.
How much time will it take?
Take about 1 hour.
1 hour?
Not for, we are, it's against the interim order.
I'll point out. I'll point
It's
out
an
how.
interim order.
And my learned friend is also here.
I appear for the intervening applicant, my lord. I am the Indian Sugar Manufacturers Association.
He's not a party.
Who
to
is
this
not-
case, no.
And who are
Yes, yes.
jute benefit?
Manufacturers Association, we made a party.
He is
In
R2
the proceeding,
You are
my lord,
jute bag manufacturer.
association. He is the
Association.
jute manufacturer.
I am, my lord, the apex body, my lord, for sugar manufacturing.
The only question is who will pack home?
We have, my lord, we have to be packed, but we have to be packed in
But,
packets, my lord, which doesn't
His
dissolve.
application is yet to be, I have
Yes,
not,
yes. I don't know.
the application is yet to be heard.
Yes, my lord, my application, lordship may consider,
lord,
because
The
we have filed
current
an
application
application
is
for
an
the learned
offshoot
single
of,
judge as well.
But we'll start at 11.
Beg your pardon, my lord?
Start at 11 after some miscellaneous student matters.
Monday, my lord.
Yes, madam.
Monday.
Because Mr. Holla,
Yes, yes.
if you are going to argue tomorrow, then better.
No, my lord.
He is
Let
not
him
there.
complete.
I'm not here.
I-
Monday, my lord,
Let him complete, no,
Then
I'll-
itself will be here, my lord.
Right.
Subject you are not.
Jan can argue tomorrow.
No, no. I mean,
You will.
I'm there, but I'll argue after him. Anyway, he's the petitioner. Let him first finish. I'll respond after that. I won't take too long, my lord.
With your lordships kindly, Manoj. Yeah, serial number 26.
26.
26, Manoj. This is regarding the cutting of trees, Manoj, with regard to rail project. If your lordship, this should take 10-15 minutes, Manoj.
Tuesday. Please. Tuesday at 2:30.
Please.
On
submission,
Lord,
item number 40 minutes.
Item 40 is that leadership issue, my lord, the head of the organization. It's already covered by your lordship's earlier judgment. If a date can be, item 40.
Wednesday at 2:30.
Grateful, I'm grateful.
Number 47, my lord. My lord, Udupi municipality disconnect my CVH line, my lord. My canteen was stalled, my lord, till today, my lord. No, they are not complied the order of single judge order, my lord. My lord, a short accommodation, my lord. Next week, any day, my lord.
27.
Please, much obliged, my lord.
My lordship tomorrow.
Order has been made.